No, I just want to know, I'm waiting, whenever you say go.
Go.
Let's go. Good. Hey, I like that. Call to order, please. Everyone rise for the flag salute.
Flag of the United States of America, to the republic which stands one nation under God, indivisible, with liberty and justice for all.
Have the reading of the Sunshine Law, please.
Notice of this meeting was published in accordance with the Open Public Meetings Act.
Okay, there will be no new business taken after 11 p.m. May I have a roll call, please?
Mayor Gilmore? Here. Mr. McLaughlin? Here. Mr. McKay?
Here.
Mrs. Kelly?
Here.
Mr. Tricoci?
Here.
Mrs. Baggio? Here. Mrs. Tyndale? No, absent. Ms. Costco?
Here.
Mr. Kroll-Pfeiffer?
Here.
Mr. Bradley?
Here.
Mr. Silk? Absent. Mrs. Caguglio? Absent. Mr. Murphy?
Do we have a quorum?
Yes, sir.
Okay, before we go into the items of business, we have to make a slight change. Case C and D have to be reversed. We have to do the Hainesport Logistics Center first before we do Seagull Holdings. So if I could get a motion and a second on that, we'll change it.
I'll make the motion.
Second.
Okay, any questions on the motion? Roll call, please.
Mr. McLaughlin?
Yes.
Ms. Costco?
Yes.
Mr. McKay?
Yes.
Mayor Gilmore?
Yes.
Mr. Tricoci?
Yes.
Mrs. Kelly?
Yes.
Mrs. Baggio?
Yes.
Mr. Bradley?
Yes.
And Mr. Kroll-Pfeiffer?
Yes. Okay, the first case is case 21-15, Michael and Tanya Wilson. Would you please step, just Michael, I guess, right?
Yes, sir.
Okay, yeah, please step forward. Our attorney, Counselor Kingsbury, will swear you in.
Raise your right hand, please. Do you swear or affirm the testimony you give tonight will be the truth, whole truth, nothing but truth, so help you God?
I do.
Thank you.
How may we help you?
All right, just want to thank everybody for their time this morning. Again, my name is Michael Wilson. My wife Tanya couldn't be here tonight. She's home with our two children. I'm here today for a proposed pool, swimming pool for our backyard. My wife and I have been Hainesport residents for 6 years now. We live at 3 Dorset Circle in the lakeside at Creekview community. We have two children, as I indicated, both attend Hainesport Elementary School. My son Michael's 3. He's there for preschool, and my daughter Lauren's at 2nd grade with Hainesport. A little bit quickly about myself and my wife. Both of us have committed our lives to public service. My wife serves as the Director of Field Operations for the American Bible Society. I work for the Department of Defense Logistics Agency. Specifically, I serve as the Chief Counsel there, where I lead an office of 45 attorneys and paralegals. So just a little bit about us. And in our spare time, we operate a nonprofit volunteer called Just for People here in Hainesport and the surrounding South Jersey area. We had the privilege and honor of delivering Thanksgiving meals to families in need over the holiday and are currently doing a coat drive. So just a little background about us and my family. Unfortunately, could not be here today. But what brings me here today again is we're seeking a pool for our backyard. I went under contract with the pool company in the August timeframe. They filed the permit. We filed the permit with the township in October. That permit was denied based on our impervious lot coverage. As you guys are all aware, and probably better than I know, the Hainesport zoning ordinance allowance is 25%. My proposed lot coverage is 39.9%. And what I'm seeking today is a bulk variance to exceed that amount. Absent the bulk variance from the board, I am and my family, we're in a hardship position. My house was built, and I'm not the original owner, so I didn't have a chance to design the house. My house was built already exceeding the boundary of 25%. My house is at 28.1%. So when you have an allowance, usually you have some wiggle room to operate within and remain under it. I don't have that flexibility because my house already exceeds that amount. So I'm looking to do a capital improvement with some nice stamped concrete around the property, and that's what brings me here today. A little bit about my property. I am on a cul-de-sac. I don't know how many people here live in Lakeside community, but it's a lot of cul-de-sacs. I am one house of 7. So my house is again, I'm 3 Dorset Circle. I provided you all with photos. I sit the furthest back on the cul-de-sac. If you look at the photo that I included in my documents, you'll see from the stop sign, when you make the left turn from Heather Lane onto Dorset Circle, you cannot see my house from the street. You see my neighbor's house, 1 Dorset Circle, who has a pool, who did not require a bulk variance because he does not have a long driveway. He has a 2-car driveway. My driveway is 73 feet long because that's how far the house sits back. As I know from Thanksgiving, thankfully we were able to have it this year because of COVID being a little bit better, I can easily fit 6 to 8 cars on my driveway. And I included a photo as well so you can see the difference. If you take a look at that photo, you'll notice my neighbor's brown fence. I'm sorry, let me direct you to it. It is the third photo in the packet. My neighbor's brown fence starts way before you can see over the maroon car, my white fence just begins. So it's a huge setback, again, as I indicated already, with the 73-foot driveway. Our concrete alone on our property, just between our front steps and our driveway, is 1,236 square feet. So we haven't done anything to the property to exceed the limitation any further. It's just the way that the house was built and how it sits on the cul-de-sac. It is an irregular shaped property. It is a narrow backyard. If you look at the other photo I included, it would be the, let me direct you there. You can see the steep slope in our backyard again if you look at the second picture. But if you look at the first picture that I included, you'll see my neighbor's yard that I said, the brown fence, it runs all the way back to meet my fence. So while my neighbor's fence starts a lot higher than mine, I have a much narrower backyard. I have a bigger front yard and longer driveway, but it's an irregular shaped property that sits back so far that, it creates a hardship. And I'm asking the board to grant relief again in the form of a bulk variance to exceed, I guess I'm already exceeding the 25%, but to exceed it a little bit further to improve the property. The National Association of Realtors, their website indicates pools increase property values by 7%. A landscape backyard increased property value by 15%. If you look at my picture, my backyard needs some landscaping. There's some steep slopes in my backyard. If you're familiar with Bancroft Drive, there's a steep hill. My backyard's parallel to Bancroft Drive. What I'm looking to do is just have some of that level out. The pool design was designed by an engineer. I have a diagram as a part of the application. They're going to include a retaining wall as well to make sure everything's level and complies with all of the required setbacks that Hainesport Township requires. So I've said a lot here already. I don't know if you have any questions for me, but I'm more than happy to answer any questions you may have.
Thank you for the presentation.
Thank you.
The information you provided us about your work and everything answered one question that I had, which was, I thought you had help preparing your request because you used all the right language, but I compliment you on it. It's very thorough.
Thank you, sir.
Does anybody on the board have a question of Mr. Wilson?
I'd asked Kathy, is it 27% or 25%?
No, in this particular zone, it's 25%. In the Lakeview, Creekview development, we have a handful of these homes that are on the cul-de-sacs where that these existing conditions of about 27, 28%. When K-Hob and Quaker were doing the homes, I'm not quite sure, obviously I wasn't here in the late 90s to see what variances that if they sought any. But many of these homes have these size driveways that the houses sit back on the cul-de-sacs and they are quite large. It's not a common one in the development, but on the cul-de-sacs it is.
Okay, can I just give an example, Kathy? That's okay for
Yes.
the group? I have neighbors across the street, one Dorset Circle. We signed up for pools at the same time. I was going to take a picture of the house, but I said that would be too much. But they have a two-car garage, two-car driveway. They are operating under the 25% allowance. They also have their pool scheduled for install in August. Same pool company, but because of the way their house was built on the same block as me, they are within, and Kathy, correct me if I'm wrong, they are within the 25% allowance. So I think that's just a classic example to show the hardship I'm sorry.
Very, very eloquent presentation, but I think everything you said up to the point where your proposed project's gonna improve the value of your property and possibly the neighborhood sort of proves your case, because your variance, if I'm not mistaken, has to provide for the benefit of the surrounding area. So I think you made that point very eloquent towards the end. I know we've been somewhat lenient on some of these properties with pools because, albeit they are really, for the lack of better words, there's some poor design in there to cram houses into spaces. So I appreciate your presentation and
What you
see
have
what
to
the
remember
board.
in this development, there's two zones, one R1 and R1A. It goes from 10,000 square feet up to 15,000 square feet. Through the development, we have many of the largest houses that are built on the smallest lots. And many of the original homeowners in that development are not there anymore. So the second and third buyers down the road are now responsible for what was put there, and they had no say. So,
I was at the property, and I acknowledge what you testified to, because I did see the,
I thought I saw you outside.
yeah. I travel a little bit. I have one question, a curious question for you.
Yes, sir.
But before you answer it, I'll tell you the reason I'm asking the question, okay? It has to do with, my question is, did you get approval from the homeowners association, to exceed, I'll say the 25%, but to get to almost 40%? The reason I'm asking is, the homeowners association there has complained about other developments in the area, and I just want to make sure, if we take action and grant your request, that you don't run into a problem by not having obtained the HOA approval. So my question is, did you get that?
I have not, sir. I've talked to Kathy and I've talked to our HOA association, and they've informed me I need to go through this process first before I go to them. So I have to go to them for approval, not only for the exceeding, but also to get a pool. So they told me I need to go through this board first, sir.
Okay, fine, and they're probably right. You have to go here eventually, so.
Yes, sir.
Mr. Chairman?
Yes, ma'am.
In the 20 years that I've been here, is that the HOA in this development does not necessarily worry about these issues in general, to be quite honest with you. So as long as we are approving everything, they sign off on that.
Okay.
And I guess the surrounding property owners were notified?
Yes, sir. I had to send out notices to 19 of my neighbors. I received the certified list from Paula, and I did that via certified mail, and she has that document. I also had to send the remaining 11 certified letters to all the utility companies and everyone else I was required to send that to. So that has been done. I also posted, as required by law, notification in the Burlington County Times, and have the affidavit, and that should be in your package as well, testifying that I've done that as well.
Okay, thank you. Any board members have any questions? Mr. Wilson? Professionals?
No, sir.
Okay, then we'll open it to public comment. Anybody who would like a question on this application, please raise your hand. If when I acknowledge you, step forward to the podium, and Mr. Kingsbury will swear you in. Do we have any public comment?
Mr.
Not-
Chairman, just for one,
Yes.
on the record, is that the existing impervious coverage is 28.1% already existing without anything that he's looking to do.
Okay, thank you. All right, no public comment. I'll close the public comment. Board, what's your pleasure?
I'll make the motion that we approve the application.
Second.
Okay, we have a motion and a second. Any questions on the motion? Roll call, please.
Mr. McLaughlin,
Yes.
Mrs. Baggio,
Yes.
Mayor Gilmore,
Yes.
Mr. McKay,
Yes.
Mrs. Kelly,
Yes.
Mr. Tricoci,
Yes.
Mrs. Tyndall. She's down really low.
Whoa.
I'm turning it the right way.
I'm gonna ask her to say that again.
Yeah, say it again. Mrs. Tyndall?
Yes.
Okay,
There it
thank you.
goes.
Ms. Costco
Yes.
and Mr. Krollpfeiffer.
Yes.
Okay. Thank you all
Good
very
luck
much
with
for your
it.
time.
Anything else we can help you with?
I would respectfully request a waiver to proceed forward at this time, if you're open to allowing that.
Yeah, you know, we've been through this, right, Bob? The only problem is that can go sour if the homeowners association raises a stink, if you start the job, you know.
Oh, no, I can't start without them.
Okay.
I can't start without,
You'd see, okay.
Yeah.
Correct,
I
I
have-
won't allow the permit to go out until I have that.
yeah,
From the homeowners, okay.
yeah, I can't
Well,
start.
I'll make that motion then,
To waive the resolution.
to wait, yeah, to give him
Right.
grant him a waiver.
Mhm.
What's that, 30-day waiver, is that what it is?
Yes.
We're gonna memorialize it next meeting, so you
What
wanna
this
get
does is
started.
It's gonna allow us to go ahead and at least review his file
Yeah.
with my construction
Yeah.
office for that.
Okay.
So I'll grant the waiver. I'll make a motion to grant the waiver.
Okay, do we have a second?
I'll second.
Any questions on the motion? Roll call, please.
Mr. McLaughlin,
Yes.
Mrs. Baggio,
Yes.
Mayor Gilmore,
Yes.
Mr. McKay,
Yes.
Ms. Kelly,
Yes.
Mr. Tricoci,
Yes.
Mrs. Tyndall,
Yes.
Mrs. Costco,
Yes.
and Mr. Krollpfeiffer.
Yes.
All
Thank
right.
you, sir. Good luck.
Thank you all for your time, I really appreciate
Okay,
it.
thank you. The next order of business is review for consistency with the master plan relative to affordable housing. And I want to go through something because I know the majority of the folks that are here tonight from the public, not next case is coming, are here for this case. But I want, by way of an introduction, I want to explain something to tell you what this case is and what it is not. And it's very important to know the difference. This is a proposed rezoning in compliance with the Township Master Plan. In other words, the Township Committee has made a decision to change the zone in this one area off of Creek Road from a residential to affordable housing. And they're asking us if it's not inconsistent with the master plan. So having said that, let's look at the other types of things. You just saw one example of a bulk variance, which this is not. You've heard stories about use variances. We have preliminary site plans that we look at, and we have final site plans that we look at. All of the last four things that I mentioned require action by the board, but before we can take action, as you all just saw with Mr. Wilson's application, I then asked for public comment. That is not the case with this case, if you will, that's coming up right now. It is not something where we're required to seek public comment. However, because of the circumstances, first of all, Mr. Scott Taylor, who's the Township and Joint Land Use Board, will present the information on this case, explain it. There will be questions from the board members to Mr. Taylor, and then we would then take action on it, and I'd request a motion in a second. Because of the complexity and because of the circumstances, I'm going to allow 15 minutes of public comment. Okay, not 15 minutes per person, 15 minutes in total. And I want to just be clear what it's about. You could ask questions about this case and this case only, which has to do with an ordinance. It does not have to do with a site plan, does not have to do with variances of any kind, bulk variance or use variance. It has to do with the zoning. So I hope that's clear, and Mr. Taylor, I will turn this over to you for your presentation, please.
I think, Paula, do you want to do a brief introduction?
Sure, if that's okay with Chair.
Fine.
So just to briefly go over the purpose of this, so the purpose of rezoning the property from R1 to AH1 is to help the township meet its constitutional third-round obligation to provide for its fair share of regional housing needs for low and moderate-income families. The ordinance itself includes the standards, setbacks, and density as required to facilitate this development within that identified area located on Creek Road. Scott, I'm going to hand it back over to you, and if there's any questions with regards to affordability, I'd be more than happy to dive into that as well.
So, thank you, Paul, and Mr. Chairman, board members. So, as Chairman indicated, this is a referral to the Joint Land Use Board under the Municipal Land Use Law. 40:55D-26 requires, as all of you know, before any land use amendment is adopted by the governing body, it has to be referred to the Joint Land Use Board for there to be a review of whether or not, is my mic on? Am I not loud enough?
Can you tilt it?
Sure. To determine whether any of the elements of that ordinance are inconsistent with the municipal master plan. So this ordinance, as Paula indicated, is being effectuated to help the town meet its constitutional obligation to provide for affordable housing. As this board knows, and many of you have been through the master plan and housing element process, going back to the first Mount Laurel decision in 1975, municipalities in New Jersey and throughout the country have been required to provide for affordable housing. Our 1996, one of the goals of our 1996 master plan, which were reaffirmed in the 2008 master plan and 2008 housing element, indicated that the goal was to meet the housing needs of a wide range of income and age levels, with particular attention paid to accommodating the township's low and moderate income housing obligation. The 2008 housing element set forth a variety of implementation strategies to help the township meet that. One of the reasons the township needs to do this is to help protect itself, A, meet the constitutional obligation. Secondarily, to protect the town from litigation or what can be referred to as a builder's remedy lawsuit. And there are numerous examples where a town was not out in front and providing for its required low and moderate income housing. Developers came in, went to the courts and said, we'd like to help this town. We would like to take this farm field or this large woodland, and we're going to build 1,200 units, and we will give the town 200 affordable units. And by staying on top of affordable housing requirements and having the production of those units, as we know, we've done some, this board granted a use variance for a 100% affordable project in the last few months. These are the methods that help protect the town from litigation and to help meet its constitutional obligation to provide that affordable housing. This ordinance does that. This ordinance sets up a mechanism and it provides bulk and zoning standards and density standards to effectuate affordable housing on the subject property as referenced in the ordinance. As the chairman further indicated, everything from street trees to traffic to land clearing and tree clearing and replanting and grading and stormwater management would all have to come back before this board as part of any site plan application. So this is simply a zoning modification of the subject property. And after reviewing, I'll take one other step. In the 2008 master plan, there were a variety of mechanisms identified. We still had a council on affordable housing that no longer exists for implementing affordable housing in New Jersey. That has been turned over to the courts. So many of the recommended specific strategies are different because of all of the different cases that have come down since 2008 in how towns are required to deal with affordable housing. This ordinance does that. It very specifically has provisions that it complies with the UHAC requirements, with all other COA and successor requirements and current case law. So this is really an updated ordinance to help the town stay ahead to meet its constitutional obligation to provide affordable housing. So we believe that not only is it consistent and not inconsistent with the master plan, but it does actually continue to effectuate those master plan goals as stated in 1996, carried forth and reaffirmed in 2008.
Thank you, sir. Do any board members have a question of Mr. Taylor?
Mr. Taylor, a couple of questions. You mentioned 2 locations where affordable housing plans or site plans have recently been approved by this board. Can you identify those locations more specifically?
I can identify the one. The one is, I think the other one was before me, but the one is the Randolph Senior Estates at the Christian Faith Assembly Church on Marin Highway.
And the other one is the Davenport, the additional 16 units at Davenport.
Thank you.
You're
And that was,
Both of those are off the Marne Highway between, sort of relatively speaking, between the Lutheran Church and the traffic light at the bypass.
Yes, sir.
Also, Mr. Taylor, the term affordability as in affordable housing has been used throughout your discussion. Does the state statutes or regulations contain eligibility requirements that must be met in order to be able to rent? And I believe these are, the theory would be these would be rental units.
yes,
In order to rent the units.
yes. They do, and I think Ms. Costco has some information and is prepared to comment on the eligibility requirements for the income limits.
Sure. So in order to become a tenant of one of these units, one, you must be employed, and you must be able to show proof of employment and stable employment. So this is all regulated by UHAC as well as COA regs in terms of what the statutory percentages of low income, and moderate income is. And all this is based on our region, which is Region 5, includes Burlington, Camden, and Gloucester counties. It is based on the median income of our particular region. And let's say, for example, somebody applies and is eligible for the very low income unit, say it's myself, I would have to have at least 20% of the median income of our area in order to rent a unit, and that looks like, so the median income for one person is $67,620 in our region. So if I were to rent a 1 unit or 1 bedroom apartment just for myself under the very low, my income would have to be $20,286. There is a certain percentage of low income. So let's just say very low and low, up to 50% of those tenants are going to fall within that income category. So low income would be $33,810 for one person. And it could be a 1-bedroom, 2-bedroom, or 3-bedroom apartment, and there's also percentage requirements in terms of how many of those are available as well, based on each income level as well. So a moderate income, which is 50% of these units will be for moderate income, and a moderate income person, the eligibility criteria is for one person, an income of $54,096. So to break that down into specifics for this community, our paraprofessionals in our district will qualify under the moderate income, as well as up to a 4th-year school teacher. And to break it down even further, for this particular development on Creek Road, the proposition is approximately 10 units would be for very low income, 26 units for low, which is, again, 50% of the median income, and approximately 36 units at 60% of the median income.
So I understand you clearly. The vote on this simply tells the Township Committee that the board agrees that the proposed ordinance is not inconsistent with the master plan, correct?
That's correct.
Correct.
Correct. And a vote tonight on this has no effect whatsoever should a developer come forward in the future seeking to build the low-mod housing on this property, because that developer would then have to submit a full site plan dealing with all aspects of the development, from traffic to density to wetlands to landscaping, to the location of the particular buildings, to buffers, and everything else that this board has to deal with on a regular basis, like we will with two major developments later tonight. And all of that must pass review of the board in separate applications that could be made down the line, assuming a developer comes forward. Is that correct?
Yes, it's also not an enactment of any kind tonight. The only enactment of this ordinance can take place by the governing body. It's just purely on a narrow issue of determining whether or not it's inconsistent with the master plan. That's all this board is charged with doing. Yes, you're right. They would have to come, whoever develops this would have to come back before this board.
Thank you for that addition.
Mr. Jones?
Again, if I, could I just, man, I just want to add to what we're talking about, what both of you said. And at that time, when somebody comes back, that's when the action would be open to public comment, which is what I said before. I just want to make sure. Okay.
And Bob, members of the committee, are we to recuse ourselves from this?
I think you should recuse yourselves, yes. I don't know that legally you're required to do so, but I think it's a good idea to do so in this case.
Any other board comments or questions?
Can you please speak into the mics?
Any other board comments or questions? Yes.
Thank you.
Okay, hearing none, I'll now turn it over to public comment on this subject only, please, okay? Just the subject relative to what Mr. Kingsbury just explained in the ordinance and so on, the zoning change, okay? Yes, ma'am, please step forward. Mr. Kingsbury will swear you in.
Actually, I don't have to swear.
Oh, I'm sorry, you're right, yeah, sorry, okay. Yeah, because we're not supposed to be doing this.
Okay, so just ask my question, or
Yes.
do I have to say who
Right.
I am?
A public comment, yes.
Okay, so then I just have a question. So this is not to rezone from a single-family home area to a affordable housing? Is that correct? Because right now it's what, zoned for what?
So it is zoned R1 residential.
So it's residential?
Right,
So you
so-
can have, what's the difference then? So if it's residential, how many units can go? Is there a limit?
So there is so the proposal tonight is to rezone the.
No, I know what the proposal tonight is, because there's plans already, like.
I was just trying to answer.
But, no, but how many homes right now at residential can be built there? Is there a limit?
I did not do a build-out analysis of that. It's under the R1 zoning standards.
The
currently,
20,000 square feet?
20,000 square.
Which is 20,000 at approximately 8 acres, so 16, 17 units perhaps at gross density.
Okay, so basically what what you're wanting to do tonight is rezone that for 172 units, correct?
No, this board is not rezoning anything.
We're here to rezone the area.
So-
No?
No, so
So, okay, that's what my question is. Go ahead.
the governing body, Township Committee, introduced an ordinance that, you're correct, rezones the property from R1
Yep,
to AH1. The AH1 zoning district has a minimum acreage of 8 acres, and 9 dwelling units per acre are permitted. If you multiply that 9 times 8, that's actually 72 units, not 172 units. So this board tonight is not doing the rezoning. That is a governing body township committee process. The process tonight is just for the joint land use board under the terms of the New Jersey Municipal Land Use Law to determine whether or not this is consistent with, or whether any elements are inconsistent with, our municipal master plan. But yes, the ordinance that we're reviewing changes this from R1 to AH1. And if this is approved by Township Committee, it still has to come back to the board, and there would be public notice in the future for any site plan application.
Right, but we've seen that in 2019, no? Right? I mean, this has been in the works since 2019. I've been coming to the environmental meetings, the
I would
planning
defer to Ms.
board.
Costco on that.
Sure, so the subject of affordable housing has been obviously a part of conversation for many, many years, but you're correct. This
And that-
issue has started in 2019, and it might have potentially been at the Paul's Tank Farm site initially, which after due diligence, extensive due diligence, it was determined that that area was not suitable for residential. There are actually 4 other additional areas in the community that were looked at as well. And yes, you're correct, this issue has been since 2019 with this particular project, and quite frankly, it could be another 2 to 4 to 6 years.
Okay. All right, thank you.
Excuse me, ma'am, may I have your name, please?
Cindy Tavermina,
Spell the last name.
Tavormina.
Thank you.
Thank you, ma'am, for your comments. Yes, sir? If you could just give your name for Mrs. Stiver.
Brian Shaw, 114 Masons Woods Lane. So I want to thank you for, spelling out that what we're talking about here tonight is consistency with the master plan. So I'll be respectful and I'll keep my remarks on the master plan. So my understanding is that current state law requires a periodic reexamination of municipal master plans under the municipal land use law. You've talked a lot tonight about the 2008 master plan. My understanding is that previously the law was that plans needed to be reexamined every 6 years, and as such, the 1996 master plan was reexamined in 2002 and then reexamined again in 2008. I know also that in 2011, the state law had been changed to extend the periodic reexamination period from 6 years to 10. What I wanted to mention tonight is the fact that the very next section of that statute, my understanding is that it says that lack of such a reexamination would constitute a rebuttable presumption that the municipal development regulations are no longer reasonable. And that's what I wanted to talk about tonight, because I haven't heard anybody say that there has been a reexamination of this town's master plan since 2008. That didn't meet the 6-year standard that was previously under state law. It doesn't meet the 10-year standard that I now understand exists under state law. We're now at 13 years. Unless I'm missing something, there has not been the statutory reexamination of the municipal master plan since 2008. So my understanding is that we're now talking about moving forward with this type of development proposal under a master plan that hasn't been reexamined in 13, now going on 14 years. I know I have a lot of my neighbors here tonight who've lived here much longer than I have and can speak to, some of the concerns that we share and some of the reasons that I think that, quite frankly, this is, there's a number of concerns with why this should go forward. But I'm being respectful of what you had said earlier about keeping this to a conversation about this ordinance as it relates to consistency with the master plan. And so I wanted to raise that concern here tonight, and I thank you.
Okay, thank you. And when are we revising our plans?
So we actually have put draft information together on that. Paula has set up a subcommittee, and we anticipate in the first quarter of next year that a reexamination report will come back before this board for draft presentations, input, and ultimately adoption.
Okay, thank you.
But just to be clear for the record, I know that the law that changed that reexamination, that periodic reexamination period from 6 years to 10 years, was signed into law by the governor on May 4th, 2011. So as of right now, even if it was 10 years from the date on which that extension had been passed, we're already past that 10-year period. We're talking about 2008, we're at 13 years.
So are there any portions of the master plan that you've identified that are inconsistent?
My
or
concern
you-
right now is about the process
or is
and
you-
about the fact,
So understood, and that's why the town has recognized
Yeah.
that and has set up a draft and set up a subcommittee, and this will be addressed in the first quarter of the year
Yeah.
to address those concerns.
I don't have specific
And-
concerns as it relates to the master plan, to the content of the master plan. I'll leave that to maybe some of my neighbors who can speak to that. But my concern is about the fact that there hasn't been the necessary reexamination.
And thank you for
Yeah.
bringing that up, and the board is into that now, and that will be addressed in the first quarter of next year.
Thanks for your consideration.
Thank you, sir. Lady in the center? Ma'am, if you could just give your name to Mrs. Tiver, please.
Sure. Hi, my name is Beth Mowery, spelled Mowery. I live at 107 Weather Hill Court in Masons Woods. I'll also be very brief, because I understand that this, first of all, we have 15 minutes, and this is limited to the variance tonight. So my question, well, let me just start quickly by saying that I don't have any issue whatsoever with affordable housing, and not even in my neighborhood. For the last 2 decades, I have volunteered in a board of director capacity for at-risk and homeless people. So I understand the need for it, and I don't object to it. What I object to is the safety and the infrastructure on Creek Road. It is not the right place to put it for safety and infrastructure. So if we're talking tonight about doing a variance change or a variance vote, and you're going to increase the density, the number of people moving in to 72 units, Creek Road cannot accommodate the increase in traffic, not only from the increase in residents, but the delivery traffic. We already have a safety issue now.
Ma'am, excuse me. That's not what we're dealing with tonight, and as...
You are. We just said that we're increasing the density from going from residential to affordable housing, and we're going to approve 72 units. So you are
That will
approving
not
that.
take place till we get into site plans, variances, and everything else. That's not what we're
If
dealing
you're
with
changing the
tonight.
zoning, you are, right? You're changing it, you're increasing the density, the number of people. Just by changing the zoning, you're automatically increasing the number of
Okay.
people and units, right?
The only reason I'm not cutting you off,
Right, I
I just want to preserve the 15 minutes for somebody else who has...
I got it, and I'll yield
Okay.
my time, because later, but before you, like, you're gonna change the zoning, which means you're increasing the number of units, residential units. Therefore, you're going to increase traffic. That road cannot handle it. We already have a safety issue in Mason's Woods now from traffic. And now you're gonna quadruple it. You need to consider that. Thank you.
Okay, thank you. Anybody else? Public comment? Yes, sir. Please give Mrs. Tiver your name, please.
Hi, Steve Para, and I'm at 119 Mason Woods Lane. I've been coming here for over a year, and I've asked numerous times if you have updated and filed the master plan with the state, and as of yet, you have not. According to state law or state requirements, you're not in compliance with what the state requires. You're past due. So I would formally object to allowing any zoning variances based on this master plan because it's out of compliance.
Okay, we are aware of that, and I appreciate your comment.
Okay, thank you.
Thank you.
Chairman, if I could
Yes.
just interject, please. You have quite a few people online. I don't know if they're online for this matter, so I don't know if you want to
Yeah,
toggle between the two.
I think we should, yes.
If there's anyone online that would like to give public comment on the master plan compliance, please unmute yourself.
No? Okay, hearing none. Mrs. McIndoe, step forward, please.
Good evening. Pat Mackin, 116 Mason Woods Lane. I understand what the meeting's for. I also, hearing what Brian was saying about we are out of date with that. I don't know how this can proceed. I was on the 1996 Master Plan Committee because at that time, the residents were encouraged to be part of committees. I'd like to know who's part of the subcommittee, and are any residents going to be included? because you have different parts of town. It'd be nice to have residents from different parts of town, because most of you are from, I think, District 3? I know you're District 2, Leela.
If I may answer that, yes, there are 2 residents that are earmarked to be requested to be a part of the committee.
To put out to the public to see who else would like to volunteer?
We don't want the committee to be too large. We want to, how many people were on the committee when you were on it? Do you recall?
Oh, there probably were 4 or 5 of us. But it was put out that whoever wanted to volunteer, because you had people that came in for the COA committee, the master plan committee.
Right.
Back then, it was encouraged. And because we lived on the other side of Creek Road at the time, the changes that Mr. Charrier wanted to make on our side at that time, thank God we were able to stop it. But I'm just saying, different parts of this community should be included. That's all. And what are the other 4 affordable areas that are under consideration?
That were past tense under consideration? Paul's Tank Farm,
Where the warehouse is?
correct. The area behind Our Lady Queen of Peace. Yeah, there was an affordable housing developer looking at that piece. Rife,
Oh, I know where you mean, that
yeah.
piece, okay.
In the rear, and, hold on one second.
And I thought Rife's was cleared for contaminated property to
Okay,
put
so I
houses
don't know the
on.
reasons why, but that developer did withdraw its intention, as well as property along Marne Highway next to Winzingers, across from Hainesport Industrial Park was explored,
Right, that's the old US,
U.S. Supply.
Yep.
Yep, however, there's a significant flood hazard area in the rear, which basically renders a large portion of that property undevelopable.
okay, thank you.
Okay, thank you. We're coming up on the 15 minutes. I'll take one more person, please. Yes, ma'am.
Hi, my name is Kathy West, Kathy with the C. I live at 107 Weatherhill Court in Mason's Woods. I just want to say, at the risk of being redundant, I don't understand how we could possibly say that something is in compliance with a plan, a master plan, which in itself is not compliant. So to me, any decision that would be made tonight would be basically invalid because you have no valid master plan to begin with. And I know that's probably redundant. And the other thing I want to say, and I'm sorry, but I took offense to the fact that you're telling us that it really doesn't matter, or implying that really doesn't matter what the decision is here tonight, because all the rest of that's going to be discussed in the township meeting. It does matter. If it didn't matter, you wouldn't be making a decision on it. So I'm just saying that just seems very disingenuous to me to suggest that this meeting and the outcome of this meeting has no bearing on what's going to happen going forward. I would suggest that the planning committee get together your master plan, get it in compliance, and then worry about deciding whether or not some new application is in compliance with your actual master plan.
So I don't know if you misunderstood or that you got the impression that I said this process doesn't matter. If you got that impression, I apologize, and I was not clear in my wording. This is the first step. This is being done for the township, by township committee, to meet its constitutional obligation to provide for affordable housing. That has been identified as a goal of our master plan going back to 1996 and carried through again in '02 and again in '08. We are here to rezone the property. This is a step in that process. So I apologize if you thought that I was trying to make light of this process. What I was trying to say, and I think the chairman, some board members, and Mr. Kingsbury were trying to say was, those specific items like traffic and lighting and architecture are the subject of what will be a public hearing for a site plan approval. This is being done and being recommended by the township attorney to help protect the town from litigation.
So wouldn't,
As we are in the process of updating the master plan through a reexamination process.
but what you're looking at tonight is for this specific development. So of course it's going to be in compliance with any master plan who has a requirement for affordable housing. Wouldn't that apply to the entire township? Why is it just this particular location that's being considered, if that's the case? Because if we have a requirement overall
I don't
to have
think that is the
affordable-
case. I think Ms. Costco just said that there have been multiple areas
I
that have
understand.
been evaluated, and the township, to protect itself and farms and other properties from potential litigation and builder's remedy lawsuit, have determined that it's in the best interest of the town to proactively provide for that affordable housing. And to do that and to commit the resources from its Affordable Housing Trust Fund towards the acquisition and to rezone this property. This was not the town's first choice to enter into this process. This is something that the township realizes they have a constitutional obligation to do that, and that's why this process is
And I am actually
happening.
all for that. I believe that there is a responsibility on the behalf of every community to provide for moderate or lower income housing. I
So
don't
if
have a
you-
problem with
so if
that at
you
all. I'm just
misunderstood,
saying,
I apologize that I wasn't clear, and I was not trying to say that this process does not matter.
I guess that's all.
Thank you, ma'am. Thank you all for your comments and pointing out things to us. You're all up to speed on things, and I'm happy to hear it and see it. So I'm going to close the public comment at this point and ask for a motion and second from the board.
Mr. Chairman, I'll make a motion that this board's review of the proposed ordinance 2021-13 is not inconsistent with the objections of the current master plan. And in doing so, we do not recommend any additions or modifications to the ordinance that is proposed. That's my motion.
Okay, thank you. Have a second?
I'll second that motion.
Okay, any questions on the motion? May I have a roll call, please?
Mr. McKay?
Yes.
Ms. Costco?
Yes.
Mrs. Kelly?
Yes.
Mr. Tricoci?
Yes.
Mrs. Baggio?
Yes.
Mrs. Tyndall?
Mrs. Tyndall? She's here. She's just not unmuting herself. Can you skip over her? She's not answering.
Mr. Goldpfeifer?
Yes. Okay. I thank you all. We're going to take just about a 5-minute recess because I'm assuming the bulk of the folks want to leave at this point.
Mr. Chairman, do we have that vote captured?
She did not respond. I don't know. We'll have to confer with Mr. Kingsbury on how to move forward with Ms. Tyndale's
If she doesn't
vote.
respond, you can call someone else.
Mr. Bradley?
Yes.
Okay, thank you.
All right, I make a motion for a 5-minute recess. Is
Yes.
that okay?
All in favor? Yes. Okay, thank you. Just give us 5 minutes. I just want, if we start going on to the next case, I don't want to have people leaving and talking, interfering with it.
I have,
And
I can't stop.
Counselor Floyd, you could, is he, where is he?
Mr.
Oh, sorry, I didn't see you, behind the podium. Pardon? All right, if you want to set up or have people move, get everybody ready.
I don't know. Joe?
Thanks.
You guys have everything?
That was a toughie, huh?
Okay.
He
Good
raised all
time.
valid points, you know?
Ed A, aye.
Mr. Goldpfeifer, it's Neil O'Brien
Who is that?
in place
Oh,
of, Mr. O'Brien in place of
Okay,
Floyd.
got it, thank you.
He wants to re-up. Consider
Oh, yeah, Paula just gave me that list. Yeah. Oh. The mayor. The mayor. Goes to the mayor, really, usually. Ah. Good, how are you? All right, thanks. Should go to the mayor.
No, it's a Mary's
So they address their intention to renew their position on the board?
I don't know.
Yeah, I tell you what, I used to require it I used to have to effectuate that.
Well, you said, like,
Tristan.
Gus.
Oh, Irene.
Irene, and then three.
Two, Gus and Tristan. Right, so a lot of them. I'm out, I'm done.
No, you're not.
It's too stressful. Very much. Believe me, I'm shaking inside though.
No, well, maybe, but whatever comes up, you have to
I try to anticipate as much as possible. Sometimes if I can't answer it, I'll say, I'll get back to you. Thank you. Hello. Dude, we're in the cornfield still. In the ears. Where am I sitting?
Thank you. Thank you. I'd like to put them in my files. Okay. And you are?
I think I'm on the list there. D-O-T-T-I.
Thank you.
And then you can just print the pages that are being amended. I can sign them.
Oh, that's beautiful.
Yeah.
Okay, that's fine.
It went well, I think, with everything, all things considered. But I figured, with that.
Okay, beautiful. Thank you.
And there's already a turf war about certain things, reasonable between the park and they might have been resolved. But I can tell you that I will stake my house will be an improvement for that. As a professional, manage a manicured property, manicured.
what's,
It's my computer's desk, whenever I. It automatically comes up. Yeah, it should be, it's all of our first letters of our
I
first
think we
name.
gave them 70 units.
Have a home, it's your house, your residence, you live in, you're across the street from a school. Can you smoke a joint?
Affordable, yeah.
Good question. I think the answer is no.
No, because you're in the school.
You're in the 200 foot or whatever, 500 foot. That's what it says. No, I think that's an absolute.
Yeah, yeah, I thought, this is what's my house, I mean, this is my house.
Huh?
You can do it.
I don't know.
I said, don't buy a house within 200.
We used to fix, we used to do the repair work.
Assuming she's the.
But Ingram
Yeah, she's, it says
went
that
into
she's
that,
on there.
this business.
She just never unmuted herself.
Make a lot of money doing it.
She made a
Close guy Walker Street. You look him up, he's, and look at that deal, but, you know.
Thanks, went better than, wait, where? Oh,
Oh, yeah, right.
Yeah. No, it was in the agenda that they, no, I realize that, but we had talked about this last week.
Just that it would have been.
No, I thought it would have been better than I thought it would. I just,
You know, I'm not against all this, but,
yeah. Yeah. No, I.
yeah, well, there was
I
no
just hope
comment, but, you know, I'm not against it, but over here is this thing that I'm gonna, you know,
Back there, not in the room, if we need them.
you know
Yeah,
what?
if we need.
Hello. How are you doing? I was worried about you. I didn't see you.
Gave him 275 grand. It's a shame, I would have bought that lot. Would have been great for me. He's got a lot of challenges. I just did a 72 unit
All
affordable
right, let's
housing.
get everybody going here.
4 buildings, 18 units a building.
Call to order, please. We're going to move on with the agenda. We're going to case 21-5A, the BCT 3 Hainesport Logistics Center. Counselor O'Brien?
Thank you, Mr. Chairman.
Yes. How many witnesses are you going to have?
100.
I have 6 or 7. They may or may not all,
You can close the doors.
I was going to ask that. They may or may not all testify, but 3 or 4 key witnesses. After I introduce
right,
us,
hold-
maybe we'll get to sworn.
Hold on just 1 second, we're going to shut
I
down
don't
the
think
door.
you can close the door.
Huh?
Ask Bob, I don't think you can close the door. I don't think you can. Bob, can they close the door or not?
Sure, I think
You can't close it? Okay, so this is different than a committee meeting. Sorry.
You can't lock it.
Thanks.
You can close it, but you can't lock it.
Huh?
You can close it, but you can't lock it.
Oh, okay.
We're all told that it's still an open meeting, but closing the doors to there, so.
You learn something every day.
Okay, sorry, Counselor.
Not a problem, not a problem.
All right.
Yeah, I know.
Mr. Chairman, members of the board, for the record, Neil O'Brien from the law firm of Archer and Griner for the applicant BTC3 Hainesport Logistics Center, LLC. This is our application for preliminary and final site plan approval for a property that should be fairly familiar to you. The property is located at the intersection of Route 38 and the Mount Holly bypass. It's also within the Route 38 Mount Holly bypass redevelopment area and subject to the provisions of the corresponding redevelopment plan. It is known as Block 42, Lots 1, 1.01, 1.03, 2, and 2.01. But that, as you probably recall, is about to change because a few weeks back you approved a minor subdivision for the property to create 3 lots in that same general area, lots referred to at the time as lots A, B, and C. Of interest to us tonight is that Lot A, which was to be and is to be 43.14 acres in size, and is proposed for the development of 2 buildings, which we'll refer to tonight as Buildings 1 and 2. So again, we're requesting preliminary and final major site plan approval for the development of the 2 buildings. Building number 1 will be 280,800 square feet in size. We'll have 241 associated car parking stalls, 46 loading stalls, and 68 trailer parking stalls. Building number 2
They need to go somewhere else.
will be 178,340 square feet in size with 163 car parking stalls, 45 loading stalls, and 53 trailer parking spaces, all, of course, together with related site improvements. Of our witnesses this evening, We'll start with 3 exhibits, which we'll introduce very shortly. We'll have others as we go on, but Exhibit A1 we'll refer to is an aerial photograph of the property and surrounding uses. Exhibit A2 will be the approved subdivision plan. And then Exhibit A3 will be our rendered site plan or site plan rendering. In terms of witnesses, tonight we have a couple of representatives from the applicant itself who will describe the operations of the building and the business model and answer some of the questions in Mr. Taylor and Mr. Miller's reports related to those specific subjects. And then we'll have our expert consultants who will deal with the nuts and bolts and the technical aspects of the application related to site plan approval, traffic, and the like. So it may be a good idea to have all of those folks sworn in at this juncture. Mr. Kingsbury, would you like them to identify themselves for the record and be sworn?
Yes.
Okay.
Could I have everyone who's going to testify, please stand and raise your right hand. Do you swear or affirm the testimony you give tonight will be the truth, whole truth, nothing but the truth, so help you God? I do. Okay.
Would you like them to identify themselves at this point, or just as they come up?
As they come up would be easy.
Sounds good, sounds good. So, Joe Piero, if you don't mind, don't go anywhere. Joe, please introduce yourself to the board and your role with the applicant and this project.
Good evening, everyone. Joe Fierro. My title is Assistant Vice President of Development for Black Creek.
Could you spell your last name, please?
Yes, that's F-I-E-R-R-O.
Okay. Vice President of
Development.
Development, thank you.
So if you could start by just describing to the board who is the applicant, what are we going to do out here?
Yeah, first, I would like to start by thanking the chair and members of the board for their time this evening. I'd also like to thank the township's professionals, both Marty and Scott, for their work and coordination on this application. It certainly wasn't an easy one, and in my opinion, the township is very lucky to have them. Well, Neil mentioned Black Creek was before this board last month for our subdivision application. I'd like to take a minute to introduce you to Black Creek. Black Creek is a leading real estate investment management firm with a proven track record of over 25 years, focusing on owning, operating, and development of industrial real estate. Nationally, Black Creek has completed in excess of 40 million square feet of industrial development. And in New Jersey alone, we have completed over 7 million square feet of industrial development while also acquiring an additional 10 million square feet of existing assets, bringing the total portfolio to 17 million square feet in New Jersey. For the benefit of the board and the general public, I would like to remind everyone that Black Creek is not a merchant builder. We build to hold for the long term on all of our development properties. We take pride in becoming a part of the town and community, and so we are committed to our investment in Hainesport Township.
So you've got significant experience with this kind of development specifically in New Jersey, and you don't just build and sell and walk away.
That's correct.
So in terms of some of the operational questions that were raised in the review letters that we received for the application, you talk a little bit about the proposed use of the buildings, operation of the site, hours of operation, numbers of employees, those kinds of issues.
Sure. So the project is for 2 speculative warehouse buildings, so we don't know the specific tenant yet, but these will be Class A buildings of institutional quality that will typically attract credit quality tenants. We expect the future tenant to operate the buildings for storing and warehousing of goods and products. Just for an example, a similar project that we recently completed in Hamilton, New Jersey, was leased to Wolf and Sub-Zero, who are both kitchen appliance manufacturers.
Could you tell the board just a little bit about, because that term is used a lot in development of warehouses, what do we mean by Class A? And you've probably already described it.
Yeah, I mean, you will hear in further testimony from our architect and civil engineer, but, you know, it's investment, institutional quality, meaning, you know, no stone overturned, quality materials, built by an experienced contractor, and incorporates many design features.
Great. So in terms of numbers of employees, you mentioned you don't know who the tenants are yet, but what can you tell the board about what they can expect?
Right, so while we don't know the tenant yet, we can't guarantee the number of employees, but our site design is flexible and can accommodate multiple tenancies, which includes 401 parking spaces and accounts for shift changes. While I can't guarantee a number of employees, based on our experience, the project could yield somewhere between 200 and 400 employees.
Have there been any changes between the concept plan that you guys originally submitted as part of the redevelopment process and the site plan that we're going to describe this evening?
There are no material changes from the concept plan with the redevelopment plan, other than some design and landscape changes based on our meetings review and input from both Taylor Design and Alimo.
Any phasing proposed for the overall project?
Our intent is not to phase this development. We plan on building these both at the same time.
But if you were to decide to build one and then the other, could that be accommodated with your site layout?
Yes, and we'd be willing to work with both Scott and Marty and include a phasing plan in the event that we decide not to build them at the same time.
We're referring to the board professionals here when we say.
Correct,
Yeah,
sorry.
No problem. This is a little bit in terms of a specific, but there's changes in the law, as you know, with respect to electric charging stations. What are we proposing here?
We will comply with the statute.
And we'll employ those facilities on site.
Correct.
Know that there is a prohibition in the township ordinance against outside storage.
That's correct. The operation and use of the site will be in conformance with all township ordinances.
Some of the questions in Taylor Design Group letter asked us to describe what kind of amenities would be on site for visitors and employees, and what kind of features would be employed in the design. You don't know the tenant as of yet, but can you explain to the board again what they should expect along those lines?
Yeah, the letters from the township's professionals include benches, decorative pavement, concrete scoring, planters, and we're willing to work with them to incorporate not all, but most of those design features, something similar to what you see at Hainesport Commerce Center, which is just across the street from our project.
And we'll work with Taylor Design Group to incorporate some of those features.
Correct.
There are a couple of obligations in the redevelopment plan that fall upon you as the redeveloper, but involve adjacent properties. One of them was a land swap with our neighbor to create the lot configuration, and it's your understanding that that is in play and that's close to completion, involving both the subdivision and the other application tonight. Is that correct?
That is correct.
There's also an obligation to address a reciprocal easement with another neighbor who isn't involved in the development of the project, but involving access from an adjacent property where the public house is, going through at this point both of those properties. That easement is, as part of that obligation, to be extinguished. Is that correct?
That is correct.
Okay. Any questions for Mr. Fierro?
I think we're probably going to hold them off a little bit,
Okay.
but thank you.
Okay, sure.
Could you just repeat the one thing you said about the board being fortunate to have hard answers? I just wanted to make sure the mic was off for that, sorry.
You all heard me, right?
I apologize.
Yes, thank you.
Sorry,
Thank you,
Mr.
everyone.
Chairman.
No worry.
Mr. Taylor's not used to the attention anymore since all the meetings are virtual.
Yeah, thanks, Neil.
As you probably all recall, a key component of this redevelopment plan was and is the remediation of this property. There's historic contamination out there, and one of the significant goals of this whole process was to get the property remediated and have it used for a beneficial adaptive reuse. As you probably know, the redeveloper, as part of its responsibilities to develop the property, takes on that remediation and is responsible for the remediation of that site. So while it's not really part of site plan application, we did think it would be a good idea to inform the board of where we are in that process, what's happening, and what they can expect going forward. And to that end, I'd like to invite Mr. Mark Foley, who's an LSRP, and Vice President for Environmental Due Diligence for the applicant. He's in-house, but he's overseeing that remediation. Mark, you've previously been sworn. Would you mind giving the board the benefit of your experience and your qualifications for the testimony you're about to provide?
Mark, before you get going, could you spell your last name, please?
Certainly. It's F-O-L-E-Y.
F-O-R-E-Y?
F-O-L-E-Y.
F-O-L-E-Y, thank you.
Correct. And I have a BS from Pennsylvania State University. I have been an environmental professional for over 30 years, covering due diligence, environmental site investigation, and environmental remediation. I have been an LSRP since 2012 in good standing. I have appeared before several boards and provided testimony regarding environmental issues.
And you're directly involved in the oversight of this remediation, correct?
That is correct. We have an outside LSRP that's been retained but from WSP, Golder Associates, who would be directly involved with the oversight.
Mr. Chairman, I'd ask that Mr. Foley be accepted for his qualification to provide this testimony.
Any objections from anybody on the board? If not, accept.
Mr. Foley, describe what the issues are out on this property, what's being done to address some DEP requirements, the scope of remediation, all that good stuff.
Sure. The property was previously operated since 1963 as a wood preservation facility. Wood preservation involves the timbers that were brought in for telephone poles and piers. And what they did at this facility is they treated the wood with a creosote, a coal tar creosote. That operation, for those not familiar with creosote's a tar substance. It's a very heavy substance. It's almost a solid at room temperature. So as part of the operation, they would heat this creosote up and inject it, so to speak, into these wood products in large vessels. During that process, they generated wastewater, which would be contaminated with the creosote. And as part of their daily operations, they being Atlantic Wood Industries, who are referred to as AWI, they may have had some unplanned releases to the environment over time, and those unplanned releases affected soil and groundwater quality at the site. The site is under regulations that consist of New Jersey Department of Environmental Protection, the Industrial Site Recovery Act, and also a portion of the plant is covered under the U.S. Environmental Protection Agency RCRA program, which is the hazardous waste program. The U.S. EPA, under agreement, has allowed the NJDEP to be the lead organization on that, so we are working with the Department of Hazardous Materials to handle the RCRA portion of this investigation. There has been numerous site investigations conducted at this property since 1985. During that period of time, a number of soil and groundwater samples have been collected to characterize the extent and nature of the impacts at the site. And in 1993, there was a considerable redo of the plant. During that revamping of the plant, they also conducted remedial actions, which included the removal of over 5,000 tons of impacted soil. And they also installed a groundwater collection and treatment system that operated till about 2014. In 2014, they discontinued that operation for the groundwater remediation because the concentrations had fallen to a point where pump and treat was no longer a viable option. As part of the redevelopment of the site, we have a couple of things to do. We have to take down the plant that currently exists over the area of contamination. That is going to be done by a group that we've retained that will handle all the residual materials that are left as hazardous waste appropriately under the EPA program. They will also handle the scrap metal appropriately and get that disposed of off-site or recycled off-site as planned. And then once the plant is out of the way, we'll be able to continue on with the remedial actions that are required. The remedial actions in this case will consist of a few things. For soils, what we'll be doing is consolidating impacted soils that are outside of the footprint of the plant And I think it may be beneficial for everybody to see what we're talking about as far as the plant, because the plant is only a small portion of the actual property. This is pardon. Yeah, got to be on mic. This is Exhibit A1, I believe. And Exhibit A1 is an aerial photograph of the property. And just for the sake of demonstration, I'll walk over and point out where the plant is. I don't know if I'm on mic, but the whole property is the dashed line here in yellow. The operational portion of the plant is actually fairly small and is located in this portion here. This was a maintenance building, that was an ancillary operation, which basically what they did there is they had some on-site vehicles. As you can imagine, telephone poles are large and heavy, and they had some on-site vehicles that required periodic maintenance. So they would.
What is the date on that map you just showed?
Yeah, no, that's a great.
Because I see the new warehouse is in there.
That's, it's, I'm sorry, it's November 23rd, 2021.
But that might not have been the date of the Google Earth photo. That's the date of our plan.
Oh, I'm sorry.
Any idea, Kevin?
I mean, within the last few months.
Current. As far as the soils contaminations goes, the primary source area is underlying the plant area. As you can imagine, these unplanned releases that occurred impacted soil that was underlying the plant, and that will need to be addressed. And then there's a groundwater source that underlies that plant. The groundwater source that is there has been studied for quite some time. As I mentioned, there was a remedial program that was in place for a number of years, but there is still a mass that is present under that building, that footprint. In order to address that mass, we're going to do what we call stabilization of the material in place. Stabilization is a process where we'll introduce materials into the underlying soil, the saturated soil. They'll come in contact with the mass that's present and help to bind it up, keep it from migrating further. But in order to polish off what may be beyond that point, we're also going to do what's called in situ treatment technologies. And that is adding an amendment to the underlying saturated soil outside of that footprint. And what that does is a contact sport. The in situ agents come in contact with the materials that continue to flow, and as it comes into contact, it destroys them, but it also enhances bioremediation. Bugs that are in the environment use this as a food source and help destroy the contaminants that are present. I should point out that fortunately at this site, it's always been the same operation. We have a good understanding of the chemicals of concern. We know how they behave in the environment, and we also know that they're not very mobile, so time is on our side. The contaminants are readily treated with off-the-shelf technologies, so this isn't something that is avant-garde or travels very far or causes a vapor concern to off-site residents or off-site buildings. This is contained within the property footprint and could be easily addressed. I should point out that the proposed construction does not overlay this portion of the site where we're going to be doing the work. It is underneath the asphalt truck court, the proposed asphalt truck court, but the work could be conducted prior to the installation of the asphalt, and at the end of the day, the asphalt will actually act as a cap, which will be protective of human health in the environment, by meaning that it won't come in contact with stormwater, and people on site will not have physical contact with the soil underlying it. At the end of the day, under the regulatory program, there'll be a deed notice. The deed notice will specify where the contaminants lie, and it'll have restrictions on what could be done. So if somebody was to go out there years from now and decide that they want to dig something in that area, there'll be restrictions in the deed notice to spell out how to do that. With that said, there's also a remedial action permit that's issued by the state of New Jersey. That remedial action permit says that every couple of years you need to go out and inspect to ensure that the site uses remains the same, there is no changes in the conditions, and that the LSRP is satisfied that the remediation remains protective of human health and the environment. This is documented with the state every 2 years. With groundwater, after the remedial strategy is implemented, groundwater will be sampled periodically over a long period of time to verify the effectiveness of the remedial action. Should something change over time, the biannual inspections will allow us to reflect on that and come up with an alternate design, which again, the idea here is to be protective of off-site residents and off-site migration. As far as construction activities go, of course, we're going to be moving soil around as part of this operation of redevelopment. And standard construction items, controls for dust and pads for the trucks going on and off-site will be in place. This will restrict nuisance dust problems from going out, and will also restrict and control soil from being tracked off-site by the truck tires. So those items will be in place.
Thank you, Mr. Foley. Mr. Foley, just a couple of detailed questions.
Sure.
Do you expect the remediation to go on past the completion of construction?
The groundwater item would continue on. The groundwater is, due to the nature of how groundwater behaves, it takes a little bit of time for it to acclimate to these chemicals that we're going to be adding, the amendments. So it would go on for a few years.
Is there a well or port of some sort that allows you to test the groundwater?
Yes, there'll be a series of wells. There'll be wells placed within the heart of the area to document that it is being reduced over time. There'll be wells that'll be placed down gradient of the area along the fringe to see how that is retracting. And then there'll be wells placed, what we call sentinel wells, that'll be beyond the known area of contamination to document that it's not migrating past the point.
Can you tell me if the known area of contamination extends beyond the site property lines?
It does not. The source area itself is mainly concentrated underneath the plant area. As I mentioned, these contaminants are not very mobile in the environment, and there has been a series of remediations that have been conducted in the past, also monitoring with off-site monitoring wells that are beyond the railroad tracks on the off-site properties, and those wells have been cleaned.
Could you explain for the benefit of the board and the audience, the relationship between your wells and any permits that you've obtained to build on this site, and any monitoring and that sort of thing, and the permitting that enables you to build?
Yes, there'll be, under the NJDEP program for the well program, the installation of these wells, there'll be a remedial action work plan that'll be prepared by the licensed site remediation professional. That's a document that's basically the cookbook of how the site is going to be remediated and monitored. And then the licensed well drillers will obtain their license through the New Jersey Department of Water allocations, and will be able to install them then. I'm not sure if that's the question you were asking, but
well,
yeah.
It kind of sounds like you're doing all the wells out of the goodness of your heart when we all know you're not. So I just wanted to tie it into how you're able to build on here and the relationship of all the cleanup and the monitoring that you're doing. Is this a state mandate that you're following as far as how you're doing it, and who's going to watch all this after you do it, that kind of thing?
Sure, yes. It's regulated under the New Jersey Department of Environmental Protection Industrial Site Recovery Act, so it is required because it had a release to the environment that exceeded a concentration that is promulgated by the state. So remediation is required under those regulations. So that is the overriding hammer. As far as the construction and locations of the wells, those could be married together because, as I mentioned, it's not within the footprint of the building. So that works in our favor. And at the end of the day, a remedial action permit, which is issued by the state, spells out a number of requirements that mandate that you have to have financial assurance, meaning that there's a set aside of some monies to continue on should the entity disappear. The other thing is that it requires some periodic inspections to ensure that the remediation is being tracked. That was a problem in the past, and that's why they have this remedial action permit program now, is to ensure that people are continuing on and continuing to monitor.
So it has some teeth, and the state is going to watch every step you're making out there.
It has that, and it has a financial element
Yeah,
because we have to provide.
and I got to say, I've lived here a long time, and I didn't really know it was that bad out there. So appreciate what you folks are doing.
Sure. And it is a very manageable situation. As I mentioned, the site is well understood, which is good. Oftentimes, we run into problems where pardon me, we have sites that have many people operating over periods of time, and you don't know what they did. But in this case, we do know what they conducted.
Mr. Chairman, I am Letitia Kelly. I'm the chairman of the Environmental Commission. Your report, or your application came before us. I really appreciate your presentation. It answers a lot of the questions that were brought up by some of the members of my board.
Sure.
I do want to state that you are going to continue this remediation, or the oversee of the remediation beyond the building. And that was one of the biggest concerns people had, where how you dealt with the soils when you were starting to move construction. Not so much the dust and not so much, the actual dirt, but the types are you taking soils from areas of the property and putting them where you're building? In other words, are you going to use contaminated soil and kind of put it where you're going to be building?
Yeah, what we'd like to do as part of the overall strategy is consolidate the soils. And what I mean by that is that the sampling that was conducted showed that there was impacts to soils that kind of scattered around the operational portion of the plant. The reason that happened is, we believe, is that, when you have heavy equipment driving back and forth across these areas, they have a tendency to track this material in different spots. Fortunately for us, the contamination in the soil that's on the outskirts of this treatment plant is shallow, less than 3 feet deep in most spots. Our goal is to shrink the footprint. We don't want a lot of stuff in contact all the time with stormwater. So our goal is to shrink that footprint, the square footage, by consolidating that material in a location that could be capped, and that cap will consist of the truck court, the asphalt truck court. And then any areas that may be outside of that area that can't allow for that grade change would be capped with 2 feet of clean fill and a demarcation layer. Again, that demarcation layer is for somebody who doesn't realize that, that there might have been a contamination issue, and they start digging a hole and they find this orange fence in the way, and they go, what the heck is this? And they stop, hopefully. So the idea is to consolidate, shrink the footprint, and cap it, so this way it's not in contact with stormwater, and it doesn't allow somebody to come in contact with it.
Thank you.
Sure.
Mr. Foley, I have a question for you.
Yes.
I have been to the site, and like Mr. McLaughlin said, I was shocked when I went out there. My question has to do with, I saw, when you were pointing on the map where the plant was.
Yes.
But way off to the left, I've never seen so many telephone poles in my life, okay?
Yes.
I mean, if I were to say that there are hundreds out there, I'm probably underestimating. It's probably thousands.
Sure.
Is the land under those telephone poles that are lying on the ground, is that subject to contamination from the creosote on?
Yeah, it may have been, but as part of the investigations that were conducted, they did take that into consideration, these laydown areas. And the laydown areas were sampled, and fortunately, it's really just along the railroad track that we found some contamination, and on the outskirts of the building. Now, part of the reason is, as I mentioned, creosote, the nature of creosote is that at atmospheric temperatures, ambient temperatures, it's more of a solid than a liquid. So once it comes out of that unit where it's been treated, it oftentimes hardens up to that viscous material, and it stays on the pole. It doesn't really come off. And I'm sorry if folks aren't familiar. Creosote is, the reason it was used is a water repellent, and insects don't like it, so that's why it was good for that application. The new poles that you see out there that the new tenant is using, that's actually treated a little differently. That's pentachlorophenol, which is a different process, and that is basically absorbed into the wood, so that doesn't leach.
And maybe this isn't a question for you, but somebody, who's coordinating all of the movement of the poles and, the whole, with the company? Because when I was out there a couple of times, I mean, I thought it was just vacant.
Oh, okay.
But I mean, there's trucks coming in and out.
Sure. I should have mentioned at the beginning that there is a tenant out there, Atlantic Pole, which is a division of Coppers, and they are a warehouse, for lack of a better term, warehouse distribution of telephone poles for the Northeast. The telephone poles are actually prepared down south and transported by train and truck up to this facility for distribution. So they're still in operation. They will continue to be in operation, I believe, till June or July of next year, and then we'll start operations on the development.
Thank you.
Yep.
Thank you, Mr. Fogel.
Sure.
I'd like to introduce our civil engineer, Kevin Webb, from Langen Engineering Environmental Services. Kevin, you've been sworn. Would you mind giving the board the benefit of your education, your credentials, and your authority to give the testimony you're about to provide?
Certainly. My name is Kevin, K-E-V-I-N. Last name is Webb, W-E-B-B. I have a Bachelor of Science degree in Civil Engineering from Bucknell University. I'm a licensed professional engineer in the state of New Jersey, in New York and Pennsylvania, for what that matters. I have provided expert testimony in forums just like this throughout the state, but never before in Hainesport Township.
Mr. Chairman, I'd ask that Mr. Webb be accepted for professional engineering testimony.
Any questions for anybody on the board? If not, it's acceptable.
Thank you all.
Mr. Webb, describe just very briefly the application, and then starting with A1, the aerial exhibit, if you could describe the property, orient the board to the property. They're probably very familiar with it, and surrounding uses.
Indeed. So as Mr. O'Brien opened with, we are seeking preliminary and final major site plan approval for this project, which entails the construction of the proposed construction of 2 warehouses. The total square footage of those 2 warehouses is 460,140 square feet. And then, of course, there are associated improvements for parking, trailer accommodations, trailer parking, landscaping, utilities, et cetera. So referring to A1, and I will mark it. This is an aerial exhibit prepared by Langen, dated 11/23. Mark it as A1. Today's date. So as was referenced before, this is a fairly recent aerial photo. You can see some of the newer development that's in the neighborhood. So this and the other 2 exhibits that I'll be referring to north is to the top of the page. So it's just the way you would expect to sort of see it looking at a map. The Mountain Highway bypass is to the right of the page. The area that's highlighted in yellow is essentially the overall site that was reviewed as part of the redevelopment plan. It includes the Nissan parcel and also includes all of what we'll call the future development area for the warehouse. So the grand total that's shown there is 50.9 acres. It is block 42, lots 1, 1.01, 1.03, 2, and 2.01. As was previously discussed, it is occupied by an industrial use, and of course the Nissan dealership is part of that overall tract. Route 38, of course, is to the south of the site, and we have commercial uses to the east. The Conrail line serves as the northern property border, and then we have residential uses to the west. The site does have its access from Route 38. There are existing driveways there, so you can see sort of the line, that's sort of the 45-degree angle is the existing site access for the industrial portion of the property. That's the subject of our application. And then, of course, within the context of this, again, this overall plan, essentially pre-subdivision, the Nissan dealership has its own accesses. The property is, of course, within the Route 38 Mountain Highway Bypass redevelopment area, and its zoning is dictated by that redevelopment plan. So with that, I'd like to quickly refer to A2, which will be the major subdivision plan. We just put this on for reference to, again, highlight and I can mark that now. So this will be A2, this is the minor subdivision lot consolidation plan prepared by Langen dated November 4th. This is the same plan that was the subject of the subdivision application previously, seen by this board. So as Mr. O'Brien had said earlier, the proposed subdivision at the time, I know it's a little hard to see at that distance, it took the 5 existing lots and consolidated them and rearranged the lot boundaries into 3. Lot A hasn't been assigned a proposed lot number yet. Proposed Lot A is in fact the warehouse site, that's 43.1 acres. That's the subject that we'll be talking about going forward. There was an opportunity to create the consolidated lot for the future Nissan dealership, 7.6 acres, that was identified as Lot B. And then there is a little shaded area sort of in the middle, a little square. That's where the existing cell tower is. So there is an existing, a now newly proposed lot to house that cell tower as Lot C, 0.1 acres. Importantly, and I'm sure this was raised at the time of the subdivision, there is a modification to where our site access will be going forward as part of this lot reconfiguration. And importantly, the cell tower will maintain its access to Route 38 through a newly proposed access easement. And I'll highlight that a little further when we get to the aerial.
The current access to the cell phone tower is a dusty dirt road.
Correct.
What's going to be done, what's proposed to be done with?
They will have access utilizing the same access points that the warehouses will use. So it will be a permanently paved roadway, a proper roadway.
All right, I don't know where that, whose property that dirt lane is on now. Is it on yours or one of your lots?
Well, it's part of the overall tract, and again, we're going to be replacing that with, the driveway that's within the warehouse's control.
So that dirt road disappeared?
Yes.
Mr. Webb, if you could also just remind the board what one of the other purposes of the subdivision was with respect to that 45-degree access coming out onto Route 38, I'll point it out.
Sure. So again, in that sort of oddly configured driveway, the existing driveway has a right-in, right-out configuration to Route 38. It's not conducive for exiting vehicles, particularly tractor-trailers, to be able to make that turn essentially at an acute angle. So we, and I'll highlight this a little further, going into the proposed layout and rendering, we're able to relocate that driveway farther to the east part of the track, have a proper orientation relative to Route 38, so it'll facilitate the truck movements that we do anticipate as part of the development.
We can probably see that more clearly on the rendered site plan. Right?
Correct.
We'll introduce that as A3.
Mr. Webb, does the plan provide for a exit from the warehouse, Lot A, the warehouse sites, through that new reverse jug handle that's also proposed? Or is this driveway that's replacing the diagonal driveway the only truck entrance?
We are proposing to have 2 access points. One would be this newly oriented driveway to the east of the property, but there will also be access off of the reconfigured jug handle at Lawrence Boulevard.
And the state's okay with that, or you still have a?
It's under review with DOT right now. We do have an application that's been pending for a couple months. We anticipate receiving comment soon, but we do believe there's no technical reason why they wouldn't be in favor of it. In fact, we believe it's a pretty significant improvement to the intersection. But at the same time, what's there now is functional. But again, we are proposing improvement. We have every expectation that DOT would approve our proposed improvements. So this is a site plan rendering, A3. It identifies plan rendering prepared by Langen. It's just dated December 2021. So again, I apologize for the distance that you have to view it, but it is a color rendered version of essentially the landscape plan with the site improvements shown. Just to again, speak in more detail about the development program. It's the 2 warehouse buildings that I mentioned before. The project as it is proposed and laid out is fully compliant with the redevelopment district's zone standards, all of the bulk requirements and all of the requirements in terms of the ancillary facilities, parking and loading, et cetera. Specifically, as we said, we had two buildings. The larger building, Building 1, is the building on the west side. It's 280,800 square feet. Nominal dimensions of the building, 300 feet deep by 936 feet long. The building accommodates two offices. The grand total of that is 10,000 square feet within the building. The balance of the building would be used for warehouse use. Those office areas are split evenly at the southwest and southeastern corners of the building. As you can see, there's car parking that's proposed on the southern side of the development of that building, and some on the west side as well. A grand total of 241 car parking spaces are proposed. 173 of those are on the south side and 68 are on the west. I do want to make reference, I know it was introduced at the beginning, we are going to augment the plan by creating some of these amenity areas for employees of the building. It is a possibility that by doing so we could essentially replace a few parking spaces to be able to accommodate those areas. So it's important to recognize that, we're currently proposing 241. That number is in excess for Building 1 of the 187 that's required under the redevelopment plan. So we have ample opportunity to be able to, lose a couple of spaces to create those additional amenities. So I want to put that on the record. And that 187 spaces, again, to remind the board, the redevelopment plan requires one parking space per 1,500 square feet of gross floor area of the building as a whole. As was previously mentioned, the plan right now, our plan, of course, was submitted before the state's requirements to prepare EV and EV make-ready spaces was promulgated, but we will comply with that. 4% of the required parking for each building will be dedicated for that. In the case of Building 1, that'll be 8 spaces, or a minimum of 8 spaces. All of the car parking spaces for both buildings are 9 by 18, and they use 24-foot drive aisles. All those dimensions comply with the ordinance requirements. The building, and in case of both buildings, but speaking about specifically about Building 1, it is a single loaded building, meaning it has loading docks only on one side. In this case, it's on the northern side of the building, and that's where the truck court will be. There are 46 loading docks proposed. 28 are required based on the redevelopment plan's requirements for loading spaces, so we're well in excess of that requirement. And we also are providing 67 trailer parking spaces, 45 spaces that are north of the building opposite where the loading docks are, and then 22 on the west side. All of the trailer parking spaces are compliant dimensions at 12 by 55. Very similar configuration, albeit a smaller footprint for Building 2 on the east side. It's Building 2 is 179,340 square feet. It's 210 feet deep, so not quite as deep as Building 1, and 854 feet long. Similar configuration, we have 10,000 square feet of office space, split evenly between the southeastern and southwestern corners, with the balance of the building being used for warehouse. Same configuration, the car parking is on the south side, and the truck court and the trailer parking is on the north side. So totals for Building 2, 160 car parking spaces total, versus that ordinance requirement of 120 spaces. In a similar way, we'll provide the required EV and/or EV make-ready spaces. In the case of Building 2, it would be a total of 5, so that would be the minimum number of spaces we would provide. There are 45 loading docks on Building 2, which is in excess of the 18 required to meet the loading requirements per the redevelopment plan, and 53 trailer parking spaces total, again, all provided on the north side, opposite the loading dock doors. As I mentioned before, but I want to reiterate, the plan as proposed does comply with the industrial warehouse component of the redevelopment district standards. All of the lot area and lot dimensions are meet the standards, the yard widths, the building setbacks, building and impervious coverages, minimum vegetated area, and residential buffer standards are all met by this plan.
Describe to the board, you touched on it already, access to and from the site, circulation around the site. Maybe just point to the areas in question and how traffic will negotiate.
Sure. Again, referring to A3, try to use my pointer so I can be on the microphone. So importantly, we talked before, you can see in the background image, this is the existing access to the back portion of the site here on the 45. We will be relocating this access slightly to the east, and we'll have a new driveway that'll propose a 90-degree intersection, so we'll have proper sight distance and proper maneuverability for tractor trailers that are there. This access point provides access specifically to Building 2, but there's a connection, and will also be able to be utilized to and from the site for Building 1. We are, as I mentioned before, we are proposing to replace the existing, what we would call a near side jug handle at Lawrence Boulevard and that existing signal with a far side jug handle. We believe that provides somewhat improved access characteristics and provides some greater flexibility for having what we believe to be a driveway that would better serve Building 1 in particular. So this signal would remain unchanged in terms of its location at Lawrence Boulevard, and there would be a driveway that connects to it. As I mentioned before, we believe the proposed geometry of that jug handle both accommodates what the state's requirements are for the traveling public along Route 38, but also accommodates the additional traffic that would be generated by our development.
And just to be clear, the first access, the one that doesn't have the roundabout, that's part of the applicant's lot, correct? That's not an easement or other access?
Correct. The subdivision created essentially, if we think about a flag lot, this was the flagpole, if you will, that is completely within the applicant's control, all the way out to the Route 38 frontage.
A couple of questions on the access, you got the two access points, one off the jug handle and the one you just mentioned. Does the applicant propose signage for each of those entrance points?
We do. We have a monument sign proposed at each one. I mean, they're identical in terms of their design, but they could be designed to be specific and provide some wayfinding between the two buildings. But as I said, there's internal circulation driveway here that's south of the two buildings that would allow interconnectivity. So I don't think we would expect driveways to be exclusive to one building or another, or one particular tenant or another, but would both be able to identify the site as a whole.
Are there security gates proposed in connection with either of these entrances?
Not at the entrances themselves. If there were going to be a secure area proposed or required by a tenant, that secure area would really be trying to secure the truck court itself. The front areas, these driveways that are common between the two buildings, the car parking would all be open and essentially, shall we say, upstream of any secure gate or any sort of accommodations like that. Any security features would be farther back on the site and not restrict circulation internally for the visitors or employees of the site. It would be strictly trying to ensure that trucks and the trucks that are within the loading docks themselves are secure.
And the site lighting, is that proposed to extend into the newly created jug handle and also down to Route 38 on the newly created entrance lane?
We do have lighting proposed within the driveways themselves. You know, there will be obligations that I think the state will impose to maintain lighting at the jug handle and the signalized intersection. Again, that's really to the benefit of the traveling public. But so there will be lighting associated with that, and we are proposing lighting at our site entrances for our benefit and along those site entrances as they go back into the site.
If you go to the newly created jug handle and that what looks to be a wooded area to the east of that, to the east of the new entrance road, is that going to stay as a wooded area or?
It would, yes. We are not proposing disturbance in this area.
Yeah.
I mean, ultimately, that would be subject to future, I think it's part of the redevelopment plan, that could be the subject of future retail development, but that's not, disturbance to that area is not proposed as part of our warehouse application.
Right, but that is part of your lot, that's part of your Lot A at the present time, or is that a separate lot?
It is part of Lot A.
Okay, so it would have to be subdivided if you put a retail in there, probably.
Correct.
Okay, but right now it's a buffer.
We'd be back before you either way.
Right, okay.
Sir?
And I was just to follow that up, and I guess that the old, probably doesn't even need to be said, but the old jug handle gets torn out, disappears.
Correct.
Is there any train access to Building 2 in particular?
There's no proposed connection proposed at this point. There's no, the existing rail spur that serves the historical industrial activity would be removed. The buildings are not designed to accommodate rail service. I think it's frankly unlikely that that happens in the future, but if there was a specific tenant who demanded that and the applicant felt that that was in their interest to do so, I think we'd be back before you with a site plan amendment, I think, to do that. But it's not currently proposed at this time, and I think ultimately it's probably unlikely in the future.
Sir, all of the roadways that you were using are all two-way, right?
They are, yes.
And with the turns and everything, 18-wheeler's not going to have a problem? Obviously, with the exception of the reverse jug handle, that's not two-way, that's one-way. But that one vertical road going to building
Here?
one, no, the
All
other.
of this, all of this internal circulation is two-way traffic designed to accommodate tractor-trailers, as opposing movements without, overstepping the center line of the driveway.
Okay, and the vertical roadway south of that first building, no, to your left,
Yeah.
there, yeah, right there.
The same way.
That's
This would be
two-way.
a two-way driveway, right?
Okay. All right, thank you.
Mm-hmm.
Mr. Webb, are you going to address stormwater, or somebody else going to do that?
I will be. In fact, that's up next. Perfect timing. So we are proposing 4 infiltration basins. This is the one that would serve the jug handle area, and then there's 4 that serve the warehouse. Each one of those is essentially a sand bottom infiltration basin. This project is designed, it was submitted at a time when now when we look back, it's essentially grandfathered under the prior stormwater management rules that were in place prior to March of this year. We still think that they're suitable to protect the environment and the neighbors, et cetera. It will meet all the applicable local and DEP regulations in that regard. It provides protection from peak flow, what we would call a detention standard, reduction of peak flows, provides the necessary water quality through the reduction of total suspended solids, and also provides the required groundwater recharge to ensure that the aquifer is replenished. And specifically, I want to point out that this plan dramatically outperforms the statutory requirements in terms of the peak flow reduction. There will be dramatically less flow coming off of this site for all storm events in terms of peak flows compared to what the existing conditions are, and in terms of what the obligations would be under the regulations. So, whereas, for instance, for a 100-year storm event, the regulations require a 20% reduction, we're actually proposing an 85% reduction in peak flow. So that we're getting a lot of bang for our buck in terms of the performance of these infiltration basins. There are some items still left over from Mr. Miller's review letter, which we would agree to comply with if the board acts favorably on that application as part of resolution compliance. Those are relatively small technical items, I think, to basically tune up some of the way specific items, spillways and things like that are depicted on our plans. But I think the design intent remains the same.
Go ahead.
There's no underground stormwater storage?
Correct.
I only asked that because in another warehouse on a roughly adjacent property on the other side of Conrail, they did propose that.
And that site that I have some knowledge of is subject to the newer standards, and it's frankly a little more onerous particularly on warehouse projects than this one would be.
So how are these tractor trailers supposed to come out of the site, and obviously they have to head west? Is there any kind of a acceleration lane that you have to put in? I really haven't seen any of that.
No, well, particularly at the signal, obviously that's not really warranted, but in case of the western driveway, again, there's ample shoulder, and our traffic engineer can speak to this later in his testimony, but there's ample shoulder there, and it's multi-lane already, so there is not a dedicated, what we would call an acceleration lane that's west of our driveway proposed. And frankly, given its proximity to the existing signal at the bypass, I mean, there's going to be well-established gaps for them to be able to utilize.
Subject to DOT permitting.
Of course.
Really? Okay.
So the new buildings will be provided new utility connections for all manner of utilities, water, sewer, electric, gas, telephone, as you can imagine. In both of those, there are existing utilities either in Route 38 or in Main Avenue, which is here, just to the west of the site. In fact, that's where we will connect to the existing sanitary sewer that Mount Holly MUA has, is in Main Avenue. We are proposing to connect to the existing water mains that are within Route 38. And again, electric, gas, and telecom will all be extended from the Route 38 area.
What's being done with that encroachment issue in the property near or off Main Avenue?
So we, speaking on behalf of the applicant, I mean, we'll work with that property owner to either, at no cost to him, either resolve the encroachments by moving the shed or anything that's currently encroaching onto our property, or granting an easement. You know, it's our intent to comply fully with the wishes of the owner to figure out the most amenable way to be able to resolve that situation. So either grant them an easement so it can remain in place, or move it at ultimately no cost to the property owner.
Is there any perimeter fencing proposed?
No, there is not. I mean, and I'll get to it at some point a little later in my testimony, there are some sound attenuation measures that will be there, but not specifically in that area.
I wanted to ask you about those too, but all right, get to that when we get to it.
Sure. So landscaping, I think, even though it's a little bit farther away, and a little maybe hard to see, we have ample landscaping provided as part of the project. The street trees, that's all these little green dots that are throughout, are provided on what little frontage we have, and more specifically and more importantly perhaps, we treat these internal driveways as if they're public streets for the purposes of landscaping. We're not trying to view this as sort of the backside of other developments and things like that. It's treated as if it were visible from all the traveling public and everything. So all told, there's 582 new trees proposed, 213 shade trees, 369 evergreens. There's another 400 plus shrubs and additional ground covered ornamental grasses. And I know Mr. Taylor's letter identified that there is some clearing that happens in this front area. Sorry, in this, at a bad angle here. We do owe a tree inventory of trees that are over 8 inches that would be removed as part of that, and any compensatory planting as part of it. So we would agree to provide that as part of, again, if the board acts favorably as a matter of resolution compliance. So the site lighting that we're proposing, we have both pole-mounted and building-mounted fixtures. All of those fixtures are LEDs. They're all proposed at 25-foot mounting heights in compliance with the ordinance. And all those fixtures are sharp cutoff style, what we call dark sky compliant. We're trying to reduce any glare from them. We have a 300K LED color temperature, which is a very warm and less glary color temperature that's been chosen. There's no spillover onto adjacent properties as part of this. And again, Mr. Taylor's letter, I know, identified a request to put house-side shields on any lights that are adjacent to residential areas, and we will add that to our plans. Again, I think we can do that without any diminution of performance of what we're getting on the ground. Solid waste management, warehouses are kind of unique in terms of how much waste they generate. It's very tenant specific. Oftentimes they generate maybe more recyclables and cardboard than they do what we would consider normal waste from an office or some other kind of building. But ultimately, as I said, it is tenant driven. We have provided places in each building, and actually really at the corners of each side where we have drive-in doors. Adjacent to that, we've identified spaces where you could put an enclosed dumpster or compactor, and that's common for, again, warehouse users to have that. The volume that they're going to generate, as I keep mentioning, is tenant-specific, but in any case, it's managed by the tenant through a private hauler. There's no burden on municipal services for any of that. We recognize that, obviously, the amount of waste they generate will dictate how often it gets picked up. And we do recognize, and as Mr. Taylor identified in his letter, specifically, we want to ensure that the tenants are managing those pickup times to do during daylight hours, essentially normal working hours, so they're not coming at 2 o'clock in the morning and emptying the dumpster. So we would agree to that as a condition of any approval. I sort of tipped my hat with the sound barrier. As I'm sure the board is well aware, the state has statutes, and I'm sure the municipal ordinances in line with the state statutes in terms of controlling noise from sites like this, particularly commercial sites and industrial sites, to sensitive receptors that would be primarily in an adjacent use or might be in an adjacent residential zone. We are proposing, and it's shown on the plans, fancy word, sound attenuation barrier, more succinctly a sound wall, to prevent sound that comes from the site that would be generated from the sound and going beyond the property lines to those sensitive receptors. Where we particularly have concerns, again, is in the residential areas that are nearby. We have considered also the proposed or the anticipated future affordable housing development on the church that faces Marne Highway. So we have considered that as part of our analysis as a residential use, residential property. We do have a barrier that's shown on the plans. We have a sound expert who can talk more specifically about the design of that and his analysis on where it's required. But ultimately, I want to point out something that's pretty important. So what we're proposing on the plan in terms of its limits is what's required to meet the state standards. And also what's dictated by the state standards is the height of that barrier. I think the redevelopment plan contemplates a sound barrier of 8 to 10 feet. Actually, 8 to 10 feet would be inadequate to protect those residential sources from the noise generated from our site. Again, Mr. Dottie will follow up my testimony and give more specifics to that. We believe that based on his analysis, not to bury the lead for him, height of the sound barrier would have to be 22 to 26 feet high to meet the state standards. Now, that sound barrier is placed relatively, it's not right on the border, it's not like a property line fence or anything like that, it's closer to the noise sources. And we are also proposing landscaping that's essentially on the residential side, if you will, the visible side of the sound wire, the side that's visible to the outside public. So there's landscaping to essentially screen the effects, and we're not looking at what would be maybe turned by someone as a big ugly wall, without consideration for the aesthetics of that. And again,
So we don't necessarily, we don't see that as a deviation from the redevelopment plan limits, but if it's deemed to be, we request a refund.
correct. And again, because we believe we have to provide what would keep us in compliance with the state statute ultimately. As I mentioned before, there are 2 site signs, ground-mounted signs, one at each driveway. Each one it's not a perfect rectangle in terms of the detail and the Black Creek standards for what that signage is, for their brand standards. But even, I think, generously providing dimensions for it, it's roughly 56 square feet. And like I said, it's not even a little less than that because of the nature, and that detail is currently shown on the plans. Ultimately, the content of the signs will ultimately be a requirement of the tenants until we know the tenants of those. And if a tenant has a specific demand or requirement to ultimately modify these signs, we know we'd be back in front of the board to seek that, particularly in the case if the sign exceeded any of the ordinance or redevelopment plan requirements for the area of the signage.
Which could also be done by the tenant.
Correct. And as I mentioned, we have received review letters from both Mr. Miller and Mr. Taylor. I tried to hit on at least some of those critical items within my testimony, but largely, we've obviously been working very closely with them to get to this point. We expect we will continue to do so, and broadly, we would agree to comply with any of those outstanding comments that I have not directly addressed.
Okay, thank you.
Thank you.
Thank you, Mr. Webb. So, Mr. Chairman, we'll try to be brief here, but I'd like to ask Alan Lothian, our traffic engineer, to just briefly describe, we submitted a traffic report, what it said, what the conclusions were, and what the plan going forward is with the DOT. You've been sworn. Could you provide the board with the benefit of your education, your qualifications to give testimony related to traffic?
I've been with Langen as a traffic engineer for over 23 years. I have a bachelor's of science in civil engineering from Rutgers, a master's of science in transportation from NJIT. I've testified before dozens of boards throughout the state, including this one. And I'm a licensed professional engineer in the state of New Jersey in good standing.
Could you give me your name again, please?
Alan Lothian, A-L-A-N, L-O-T-H-I-A-N.
Thank you.
Yeah, because you have been here already, we've been through this, so yes, you are definitely acceptable.
Thank you.
So just briefly, Alan, just refresh the board's recollection of what your conclusions were in your traffic report.
Mr. Webb covered access, circulation. If anybody has any more questions on those, I can definitely address them. We did prepare a traffic assessment of specifically the intersection of Lawrence Boulevard and Route 38 and our new driveway leg, which replaces the existing near side jug handle, and also the right-in, right-out driveway to the east, which replaces the approximately 45-degree angle driveway that exists today. I'm going to speak a little bit about the trips. The site overall, the two warehouses generate what would be considered not a significant increase in trips. It's less than 100 peak hour trips during the weekday morning, weekday evening peak hours, which generally falls between 7 to 9 a.m., 4 to 6 p.m. We are under those 100 trips, which is the threshold with NJDOT, the New Jersey Department of Transportation, and ITE. Speaking about truck trips, we're anticipating during those peak hours, 11 truck trips during the AM peak hour, 14 truck trips during the PM peak hour. In any one direction on 38, we're anticipating approximately one new truck trip every 15 minutes on average during those peak hours, which is going to be imperceptible on 38 itself. The analysis that we prepared indicates that the driveway to the east will operate at a level service C, which is acceptable or better during those peak hours, and the signalized intersection will operate at an overall level of service with the improvements identified, the far side jug handle and tying in our site driveway into the jug handle itself will operate at overall level of service B with all movements operating at level service D or better. So there, as was indicated, we have an application before NJDOT. They're reviewing that now. That includes a traffic impact study. That includes the design plans, the initial design plans for the far side jug handle and our driveway to the east. And we're anticipating comments on that very shortly.
Did you attend a pre-app meeting at DOT?
We did attend a pre-app meeting at DOT. We discussed it in there. It was generally looked at as a favorable alternative to what is out there today.
So I'm having just bear with me, I'm having a little bit of trouble, but all the testimony's been great, and I know you folks have done a lot of work here, and I'm sure you have the answer, but I just need to know it. I'm just not satisfied with the size of the acceleration lane coming out of that east driveway. If they're heading west, the planner, the engineer, that said there was inadequate curbing or roadside. How big is that? How big is that area? Is it?
Yeah, there's full width shoulders.
Shoulders.
That are to DOT standards. I don't know exactly how, off the top of my, I believe they're over 10 feet wide, the shoulders.
So, okay. Scott, are you satisfied with the ability of a tractor trailer to come out of there and gain some speed to get going, in a westerly fashion?
I would defer to Marty, but more importantly.
Marty, yeah, maybe I should be.
The DOT really has.
Yeah, I figure they do, but I just, I just like to sort of see it, you know what I mean? What do you think, Marty?
Well, we have to defer to DOT. They have control over the whole approval of the new facility, so.
It would have been nice to see something on the plan. I mean, we didn't show anything on 38, any kind of shoulder width that I saw. Just a layman, I'm not educated on these matters. That's,
If I may, in the plan set, there was a truck turning plan that shows truck turns all throughout the site, including at that location.
Well, I see that, but I don't see, again, from a layman's point of view, how the truck's gonna get going. Being a truck driver myself, I know it takes time to get going.
One thing that I also didn't point out is our analysis didn't take into account the removal of the existing operations on the site. Currently, there's tractor trailers that enter and exit via that angled driveway, and
Well, granted, but this is the town's opportunity to fix some things that are wrong, and I just don't want to duplicate things that are wrong. So I would ask that this get clarified at some point. At least show us the width of the shoulder and
Well,
how the things are.
that question would have to go to DOT, and they would have to address it one way or the other.
Okay, and again,
We can ask them to do that.
We'll certainly.
yeah, and I would like to see that. And again, I respect everything you've done, and I'm sure you've looked at everything from soup to nuts, but I have a question that needs to be looked at.
We'll certainly provide copies of our DOT permit when it's issued.
Okay.
I have a question on the number of vehicles. I'm looking at that site and I'm saying that you're talking about adding, what, less than 100 vehicles and certain, but then there's that new warehouse directly across the road, and that's added some traffic, and then right behind you is gonna be another warehouse facility that's gonna be adding more traffic. How do you take all of that into account and what the sum total is, each individual, but what about the sum total of what it's adding to that whole area?
We included the approved developments at the time of when we did our traffic impact study. So we included those as background traffic, additional background traffic on top of what's already out there.
And you stated your times were, what times for the morning?
What I stated was typical street peak hours are 7 to 9 in the morning and 4 to 6 in the evening.
A lot of those warehouses there's a 3 o'clock change. I live on Lumberton Road, and I cannot get out of my driveway at between 3 and 3:15. So you have to take that into consideration for people that are traveling there.
Yes, so when we did our counts, we counted from 6 in the morning to 9 in the morning and 3 to 6 in the afternoon. And we found that the peak hours were on the street when there was the most volume on the roadways was 7:45 to 8:45 in the morning and 4:45 to 5:45 in the evening. So during those other time periods, volume on the overall roadway network was less.
Mr. Lothian, that the,
It's in,
that the,
aside
you
from
finished?
this
I didn't mean to cut you off.
Okay, yeah, I'll accept what he says, but, I just know what I deal with.
I have a question. How can you calculate the number of vehicles going in, coming out, and you don't have any idea who the tenants are and what their businesses are like?
So it's based on industry standards. There's the Institute of Transportation Engineers. They come out with a trip generation manual that looks at different types of uses, and one of them is warehouse. So we look at based on the square footage, and we look at the most conservative ratio out of that manual for that type of use.
It's like counterintuitive. They've got a ton of parking spots for tractor trailers and only a couple go in and out.
Well, it's only a couple going in and out during the peak hours. During the course of the day, we anticipate approximately 125 trucks.
To both warehouses combined.
To both warehouses combined. That's over the course of 24 hours.
So let me get back to my question. On the traffic lights at the jug handle, as reconfigured, are there gonna be any adjustments of those lights with turning arrows?
Yes, so
You're gonna have cross, people making a left, people making left the opposite way.
yeah, so for the side streets, there's going to be an advanced left for the northbound and southbound left turns coming out of the side street, both Lawrence Boulevard and our driveway and the jug handle. And then it will also be permitted. So there'll be a time set for those left turns to come out, and then it'll be open to both left throughs and rights to go.
So you mean like an arrow, like a green turn
Left turn
arrow?
yeah.
So I have it's kind of like a reverse question. So would it be safe to assume that trucks would be possibly leaving the site more so in the morning than in the afternoon, and then vice versa, coming Are they coming back to the site in the afternoon, or these types of, again, we don't know who the tenant is, but is there any, these type of warehouses, is there any correlation between in and out and the hours of trucks in particular?
Typically, the truck peaks are during the middle of the day, and I did identify when what we anticipate for the street peak hours. But again, and this is, again, based on, as the question was raised before, based on industry standards, we're looking at, in the morning, 7 entering, 4 exiting, and in the evening, 3 entering, 11 exiting. So that's more entering in the morning, more exiting in the evening, to your question.
More entering.
Yeah, but I guess what, beyond those peak hours, there's lots of other hours that's going to be adding a lot of truck traffic to that section of 38. I mean, is that something the DOT is going to be more focused on?
Well, they're evaluating our entire application, all the vehicles coming in and out of the site, the operations at the signal, the operations at the right in, right out driveway, and the geometry of all of our proposed.
I don't know about the rest of you, but maybe it's because I'm retired, but there seems to be a lot of traffic these days, all hours of the day. It's not only just the rush hour, and I just, have these concerns that we're going to start seeing these traffic jams along 38.
Well, the pandemic affected that as well.
Well, we're very lucky that 38 is better equipped than 73 and 70 to handle what traffic is
Beaumont
out there.
Highway.
And that's probably why these folks have come here. But, I mean, is it safe to assume that a truck leaves from somewhere in the morning to come to your facility, and that's why you're saying maybe they'll show up late morning or midday, and then they're gonna leave your place to go somewhere else, or maybe back to where they came from, so they're back to work, they're back home later in the day, so the traffic would essentially be more in the middle, like late morning?
Yeah,
Early
again, it's
afternoon,
typical
in and out?
It's typical between late morning, early afternoon. Like, that's why I said during the middle of the day is when the peak of the trucks is
Right, okay.
anticipated. And again, it's very, very tenant specific whether the trucks are, on site or whether it's outside vendors coming to the site as well.
So, your testimony is that the truck traffic may be more compressed towards the middle of the day than really early or late in the day? Because you mentioned only a few trips, like in the early, in the morning and in the afternoon. 11, you said, well, I heard the word number 11.
Yeah, 11 truck trips in the weekday evening peak hour,
That's not a lot.
And the idea is keeping the truck traffic on the roads when there isn't as much activity on the roadways.
That's true. Yeah.
For more efficient operations.
Yeah, I hear you, yep.
I have I'm going to call this a softball question, for lack of a better. I'm looking, these papers that Langman prepared, it's specifically CS 201. And you're welcome to come up and look at this one instead of, if you want. My question, it has all these things we've been talking about turning lanes,
Very confused.
okay, and to help the traffic unit. But it makes, and as I said, this is like, I just don't understand this at all. Every one of them has the traffic moving WB-67. And every time I've seen something like that means westbound 67.
No, it's wheelbase. So wheelbase, and then these are specifically Title 39,
No,
which is.
that's, I said it was like softballs coming from me. I didn't know what this meant, because I look at it as a highway, and I'm saying, where's that highway? But thank you, appreciate it.
No problem.
I have a question. Mr. Foley testified earlier that there's currently some tractor-trailer traffic with the existing operations. Do you know what the count is of the existing traffic right now with the operations that are there?
I do not. Whatever's out there now and whatever was in operation when we did our counts is included in the background of our counts. We counted at Lawrence Boulevard and Route 38.
Okay. It's kind of a little bit of an offset question, but the testimony was that the Conrail was no longer going to be in operations for the site with the proposed. So is it safe to say that Conrail is now no longer going to operate past its current transfer station? Because I believe right now it does continue to the site daily. I hear the train around 2:30, 3 o'clock. I know it does not go over the bypass any longer.
I think Mark was referring to the rail spur that's
Oh,
actually on our
that
property.
goes into, that's right, where it drops off.
Correct.
But do you know what the status will be of the train, the rail? I can't imagine there would be any other need for it to go past
Transfer station.
the transfer station. Okay,
That's not a bad thing.
thank you.
Does anybody know if that's the spur that went out to Fort Dix way back? That was it, right?
Yep.
Okay.
Can we go to Tom's
Spur
River or
on
something?
the wood products property?
No, the line.
The actual
The
line.
line is the one
That went to Fort Dix.
Goes right through Mount Holly.
Yeah.
Goes right past the old Agway store, which is an Agway, and continues out on the back side of the landfill.
Yep, all the
and
way.
It continues out past Smithville.
I believe it even goes into Ocean County.
Trilco used to be on that line, that building material guy.
Could hook up with the old UTT and
Yeah, that's all, it's not,
Could I ask a stupid question? But it might help clarify some things. When a tractor trailer comes into the property, is it just offloading the trailer in the dock and then perhaps picking up an empty trailer and leaving again? Or is it waiting to be offloaded? I know you can't say specifically because you don't know these tenants, but what's the norm? Is the norm that they do a turnaround that they would then either leave empty or pick up an empty trailer and then leave? Or do they sit and wait? Does the driver sit and wait to be offloaded? Because that would affect the timing.
As you said, it's
Yeah,
tenant-specific, but it's a combination of all those things. They could be picking up a full trailer, they could be picking up an empty trailer, and, they could be leaving without a trailer. It's
So it could
a
be-
variety.
They could be there for an hour, they could be there for,
Or they could be waiting
5
there for their trailer to be unloaded and reloaded. There's that possibility as well.
so that would stagger the times that it was late.
Mr. Langen, while you're up there, one last question with regard to the new access driveway off Route 38, the so-called pole and flag lot description. What design measures have been put in place for that driveway to prevent landowners left and right, the Nissan on one side, the bar and motel on the other side, from using that driveway as an access road into their respective sites?
Well, I don't believe any, aside from it being private property, I don't believe there's any, yeah. Are you talking about from 38 or from the individual?
I decided I wouldn't ask leading questions, but is the road going to be curved?
Oh, yeah, it will be curved.
And so-
There will be
so
no,
Curving will be such that
there won't be access
you won't be able
driveways.
to drive off Nissan onto that exit road or drive off the bar property onto the exit.
That's correct. I misunderstood the question.
No, that's all right. Probably the question is bad. And then the last part of that question, I just, explain to me that the drawing that I'm looking at, that access road seems to widen as it approaches or gets near last 100 feet or so to Route 38, or am I reading that wrong?
No, you're reading it right. That's to accommodate the truck turns as they enter the site. So it's to allow for two trucks to go entering and exiting the site at the same time.
Okay. And is that driveway going to be striped to clearly indicate it's a two-way drive?
Yes.
Okay. And does that striping continue throughout the property on the circulating roads?
I believe so, on the perimeter road.
Yeah, well, yeah, circulating, perimeter road, whatever you want It's just not a big wide black lane.
No.
It's a yellow line down the middle.
with brakes as necessary.
Okay. All right, thank you.
Thank you.
So, just a little bit more affirmative testimony. We talked a bit about the sound attenuation wall. Would you like to hear the analysis that led us to conclude that we needed that wall and our compliance with DEP noise regulations? We have the designer.
For one member, I think yes.
Okay, very well. Mr. Dottie? Norm, state and spell your last name and your professional affiliation for the record.
Sure. I'm Norman Dotti, D-O-T-T-I. I'm the principal of Russell Acoustics. I'm a consulting acoustical engineer, and I'm midway through my 51st year of being a consulting acoustical engineer. I have a bachelor's degree from Stevens Institute of Technology, master's from NJIT, and a dozen postgraduate courses in acoustics. I've been a consultant to the Department of Defense on classified work in acoustics. I developed and taught the Advanced Noise Control course for the U.S. Department of Labor's OSHA Training Institute. I'm an appointed member of the New Jersey Noise Control Council, which writes the noise regulations for the state. And I've testified in local boards such as this, county courts, state court, and federal court in New Jersey as an expert in acoustics.
Thank you, Mr. Dottie. We requested Mr. Dottie.
I think, Mr. Dottie, weren't you here once before, Hainesport, or not?
Not sure. After 50 years, it sort of blurs together.
No, you know what I think it might be? You were here a month ago when the cases were coming up, and then this one was held off. I think that's where I saw you, but in any event, does anybody on the board have any questions of Mr. Dottie? If not, it's acceptable.
Thank you.
So much. So, Mr. Dottie, if you could describe the applicable regulations, how is sound regulated? What are the limits? How do we study it? How do we control it? And what have we done specifically here?
Okay. The state of New Jersey has a noise regulation. It has since the early 70s. It's NJAC 7:29. It sets, for residential, which is the area where I have concern here, sets residential limits of 65 dBA during the day, day being 7 a.m. to 10 p.m., and 50 dBA at night, 10 p.m. to 7 a.m. dBA is a commonly used metric. It's the primary one the state uses. It gives an instrument essentially the same response to sound as humans do. It relates very well to loudness. And so that's what we applied. Hainesport does not have a state-approved noise regulation, noise ordinance, I should say. Submitted one back in the early 90s, but it was disapproved. Even if it was approved, it would have the same limits as the state regulation, so I don't know that it matters. So what we did here was to look at the proposed use, and in particular, the truck operations around the site. The truck, of course, is a moving source of sound. As it approaches or passes by a listener, sound level builds up to some point and then drops down again. As you heard, and I was interested to hear the testimony from the traffic engineer, truck operations at a warehouse are really not all that frequent. They're minutes apart, so you don't have a steady din from a warehouse. You have individual sounds moving around the warehouse. I've been at many warehouses actually measuring them, which is one of the places we get our sound data from. When I present the results of our analysis, you say, well, where did these numbers come from? One answer is, I've measured a lot of them myself, and then we cross-check that with the Department of Transportation has something called the Transportation Noise Model that has sound level data in it, and we use the heavy tractor trailers, those WBs you were talking about, at 20 miles an hour under acceleration. And our numbers agree very nicely with the government, I'm happy to say. So we model the site the routes, the terrain, the buildings, everything that we can think of to throw in there into the model, following an international standard for this purpose, and project what the sound levels will be. We can use that model also for looking at mitigation measures. But something else we do, and we did here, is we also measure what are the existing sounds out there now? What are people hearing now?
Yeah.
It's labeled as actually
A4, which is,
label 5.
so we have two exhibits, Mr. Kingsbury, that Mr. Dottie will use. A4 is his sound model, and A5 is ambient sound levels. We've introduced A5 first, if that's okay. But we can flip the numbers if you like.
So what we did was set up environmental sound monitors around the site. Here's an aerial of the site, and there's 3 markers on here. One right across the railroad tracks on the north side, and then 2 over on to the west of the site, close to the property line there. And we measured the existing sound for 72 hours around the clock. This was done September, mid-September 15th through the 18th. And you're seeing the graphs here for the 3 locations. This is the one up on the north side, and then we have number 2 down near Route 38, in the corner residential area, and the number 3 back along near the railroad tracks, all at the same time. And what you're seeing here, each red bar shows the minimum to maximum sound level during an hour, and there's a blue box in there. That's the average sound level during the hour. The green line shows the state limits. If they were, these are the limits that the site has to meet. They're not the limits that the ambient has to be. The site is not responsible for what the ambient is. What this shows...
Norm, in other words,
Sir.
you're not responsible for, obviously, sounds that don't come from your property.
Correct. So if you look at what sort of sound levels are out there now, again, this is without the site, the proposed site operating. You're looking at sound levels, well, just as a reference, I'm pointing at 50, the nighttime limit here. We have limits from mid-40s to over 80 dBA back behind the church. Maybe that's a train going by, but it's still part of the ambient. Residential areas to the west, again, sound levels of mid-40 to not unusual to have it to 75, a few instances over 80, same thing all around. Route 38 is a big noise source.
And those are the sound levels now.
Correct. Now, into that, at night, we can't make more than 50 dBA from the neighbors, which is, if you look carefully at the graphs, is we're not putting out a heck of a lot of sound. Now, but we're still subject to limits. So the model that I mentioned,
You're back to A4.
yes. Pardon me. This is a sound level contour map. You can see the buildings, railroad, Route 38. The red lines here are all different ways that a truck can travel around. We have trucks moving around the source there. And as you get further and further away from the truck, of course, the sound level decreases. But it doesn't decrease enough where we're even close to it. So we designed a sound barrier. As you heard earlier, the height is not a given fixed height. It depends on, we made it taller where it had to be taller, and where it didn't have to be as tall, we made it not as tall. And it starts at the western entrance exit there, wraps around the building to the west, comes up along the back. By the way, we did include, as we mentioned, the building, I don't know, proposed building or is under development or whatever, it's not there now. That proposed residential building along the back, we put that into the calculation. Pardon me. end goal was, of course, to have a worst-case condition. The state limit is predicated on maximum sound level. So when the truck drives by, it's not what it is on the average, it's when it drives by, what's the loudest it is at a particular listener location. That's what we're limited to, and that's what we model in there. And the proposed wall around the site will comply. They have to comply. The state regulation is a performance standard, so they have to meet it. They have to meet it when they start operations. They have to meet it 5 years from now, unless the regulation changes.
And so the levels are meant for the sound coming from our property?
Yes.
What's the wall look like? What's it made of? And what is the maintenance, if any, that needs to be done on the wall over the years?
The wall can be, actually, we don't pick what the wall has to be made out of, other than to say that it has to be substantial enough so that the sound that tries to go through the wall is at least 10 decibels less than what goes over the wall around the side of the wall. There are a lot of different products. People make them out of concrete panels, wood. There's a commercial product that's basically 2 sheets of T111 plywood on a 2x4 frame in posts. That's a very common one. State of New Jersey's built them out of all sorts of things. Once they're massive enough, making them more massive, thicker, heavier, et cetera, doesn't do any good. So whether it's, 3/4 inch of plywood would be sufficient for the attenuation that the barrier needs. For the record, I'm not advocating that this thing be built out of 3/4 inch plywood, okay? But it gives you a sense of how heavy the wall needs to be, and it doesn't have to be heavier than that. So if they chose to make it out of a tilt-up panel, concrete panel that was, say, 2 inches thick, okay, but making it 6 inches thick would not make the sound reduction any better. As far as maintenance goes, clearly if it was made out of wood, it would be pressure treated. But generally, you don't do anything to them. You don't have to go out and drain the noise out of them once a year or anything like that.
Well, maybe while you stand there, I'll ask Mr. Webb. Mr. Webb. Yeah. What's proposed for this site?
So we didn't specifically identify a material type on the plans, but in conference with the applicant, the product that they have favored using on other sites and what we would propose here is actually a PVC product. It's essentially built almost like a slatted fence, except there's no gap between the slats. They're interlocking so that sound has no opportunity to go through the wall. So it is a solid fence that's built essentially with vertical posts, and you put slats between them that interlock.
That's AIL sound wall?
Correct.
Okay.
So, and that comes in a variety of colors. They're all, frankly, earth tones. We would choose one to the discretion of your work professionals if you choose to do it. That would match the building and would be complementary to the environment. It's not going to be bright orange. It's going to be some muted tone. Again, some sort of earth tone that will be similar to the treatment of the buildings.
And height?
Yeah, I was just going to say. Yeah, didn't you say at some points you were thinking of 20 to 26 feet high?
22 to 26 feet based on Mr. Dottie's analysis, but I'll let him take credit for those numbers.
That's taller than the walls in this room.
Correct.
A lot taller.
The numbers, we start here, this corner, should I maybe write the numbers on here?
You can.
Okay. Starting at the corner up here, 24 feet.
And that location is not exactly what's shown on the Langen site plans either. You're saying that it goes all the way to the driveway?
Well, it just comes around, just around the corner, right there's where I am.
Okay,
Not the whole way to the driveway.
okay. No, but I'm saying, I think the Langen plans only had it coming about halfway between that western end of the building and the entrance drive.
This is my model.
We'll make sure to rectify that Norm's model is accurately reflected where we have to put the attenuation.
And then, Mr. Chairman, if I can, while Mr. Dottie's marking up that exhibit, in the redevelopment plan that was adopted for this area, it specifically had a requirement that all landscape buffers shall have sound attenuation fences or barriers as necessary, and they shall be 8 to 10 feet in height. It was done as a very specific range, because we knew we had residences in the area. There was also a separate requirement that said all sound levels must comply with applicable state noise regulations. I don't think the two are mutually exclusive. I think that in an abundance of caution, it's probably more appropriate for the applicant to request a variance for the increased height of whatever Mr. Dottie's numbers ultimately are in those locations, and for the board to consider that and evaluate that based on the testimony, only because the language in the redevelopment plan was so specific, saying that it shall be between 8 feet and 10 feet in height. And the two standards, I don't believe, are mutually exclusive, but I think given their site configuration and constraints, they can provide that testimony.
So the heights, I marked them here, and I can get one in a more specific location where this is from. You start with 24 feet, goes up to 26, 27, 26, and 22. Pardon me. When you have a sound barrier casts what's called an acoustical shadow. So imagine, I'm a sound source, you're the listeners, we put up a barrier here. The sound that you hear is not direct from me to you, it's going over the top and is scattering down there. The taller the barrier, all things else being equal, the more attenuation the barrier produces. Well, the height of the barrier is going to depend on how close you and I are. But it also gets a little more complicated. If I have a reflecting surface behind me, like a building, a warehouse building, my sound, I'm radiating it all around the place here, bounces off of the wall and then comes back over the top, and it effectively is a new noise source at a higher elevation and is therefore less effective. So when you have barriers close to buildings, then, which is desirable from the standpoint of you want to have the barrier close to the sound source, but it also gets closer to the building, so you have to take that into account. And that's why we get these taller kinds of barriers near buildings. If you didn't have buildings,
It sounds like you want to build a wall higher than he does. Can you guys maybe work that out? We don't have to waste like another half hour on this stuff.
Well, and the only reason I was saying was, when the redevelopment plan was written, it was at a very preliminary layout
Work it out.
phase. And,
Come on.
and it sounds to me like Mr. Dottie's testimony is to comply with the.
I see, he wants to build the Empire State Building, you want a
No,
cyclone fence.
and we didn't, and that was just an initial height that was put in the redevelopment.
Okay, well, let's
So
work it out.
I'm saying to move through, the board may want to evaluate that as a variance and grant that height to
Well,
comply.
but with your recommendations, I hope.
On the design, yeah, I mean, we're
Yeah,
happy to
all
work
right.
with the civil engineer.
Okay, well,
Yeah, just in support
I'll
of
beat
that,
it to death.
very briefly, we provided testimony, I think, that our study shows that the height is necessary.
Okay.
I suspect, Mr. Taylor, correct me if I'm wrong, redevelopment plan was probably written without the benefit of a direct sound study for this permitted use. So clearly, there's a benefit. I think we'd satisfy the criteria for a C2 variance.
sounds like it, yep.
Because we're helping out our neighbors. It's not about a benefit to the site directly. We don't care. We do care, but it doesn't help us specifically in terms of the property itself. So I think we meet the criteria.
I'm sure you're gonna address it from the sound.
yeah, it's great that you did include the idea of a barrier of some finite height in there. A lot of people don't think to do that. But for this configuration, it needs to be taller than
Okay,
10 feet
great.
in order to work.
We'll figure it out.
That's what we did.
Thanks. Half hour.
May I ask a question?
Yes, you may.
For
through my own experience of where I live, one of the questions I have is that when the trucks are jockeying back into the trailers, there's a backup beeper. Does the state have a requirement of the decibels of what they're allowed? And the reason is, I've dealt with Whitesell for many, many years in regards to this, where I live at in Lumberton, and I had them reduced because the sound waves carry when they are jockeying back into those trailers. Do you have any idea, especially where the docks are here, do you have any idea if the state has a requirement for those decibels for the trucks for the backup beepers?
To answer your specific question, no. Backup beepers are actually mandated at the federal level by OSHA under certain circumstances, not all circumstances. My experience with over-the-road trucks is that a lot of them don't have backup beepers on them. They're not required by law.
Correct.
There are technologies now that make backup beepers sound a lot quieter, they don't do that beep, beep, beep sound. They make more of a whoosh, 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 and and they're being phased in. We're seeing them used with very great success.
That's where my concern is for the residents that live where the building, I guess it would be 2, or building 1 would be the biggest one, is where those docks are and they are jockeying back into there, that sound, especially depending upon the wall itself, can that wall diffuse those sounds of that back?
It will attenuate sounds from anything over there, whether it's the truck engine, a backup alarm, a yard tractor running around, a lift truck, whatever. It'll attenuate all of those sounds.
The other reason I ask is that it's from an enforcement end, when I'm getting phone calls for noise, is that it's something I think that if the board were to approve this application, is that that's something that we have to look for the tenant, that they have to be, whatever tenant may go in there, that they're gonna have to be, understanding of where their location is and those backup beepers.
People need to act responsibly
Okay.
Wow.
in many things.
Okay, thank you for your time.
You're welcome. Questions?
I have 2 questions for you.
Yes, sir.
Where can I see a 26-foot high wall?
I can show you a 32-foot high wall.
Okay. And then how is that maintained?
Aesthetically.
I suppose nothing is maintenance-free, but there's nothing you need to do to it. The color is...
No. When we have a hurricane in the middle of August, then what happens when in September, and it has to get repaired?
If it gets blown down, then it would have to be replaced. Just like any other thing.
And,
Yeah, they don't just sit on the ground. From an engineering standpoint, from my mind, the hardest part about them building the thing is the fact that it's a sail that's 24 feet high by however long, and the wind load becomes a significant factor in the design, not the acoustics of it.
Right.
And they do that stuff.
It's a problem, I can see.
Yeah, it needs to be done right.
At some point, we're gonna work out the size of the wall, right? I mean, that doesn't sound like it's gonna happen tonight, does it? Unless we're gonna be here till midnight on this wall.
Anything else?
You wanna build it certain high, and Marty, you seem to be, and Scott, you seem to have.
No, I was just relating what the ordinance was in the redevelopment plan. It said 8 to 12. So if they want to do 24 to 26 to comply, then I was just saying then they should request and the board should consider granting that as a variance.
I just don't think we should minimize this wall. We
Right.
sound like we're trying to push it off.
Right.
You know, it needs to be addressed because I can tell you, working in warehouses, that sound is an issue.
Right.
And if somebody decides to unload a truck at 12 o'clock at night, you're gonna hear that far away if this wall isn't right.
Right. And that's why I think based on Mr. Dottie's testimony, he's saying this needs to be 22 to 26 feet in height. to meet that requirement.
We did,
No, that's what they think.
Yes,
And why are we?
so I think, well, I'm just saying, it was written otherwise, so I think the board should consider and grant that as a variance.
I mean, a variance to build it 24 feet high?
Yes.
I'm back in reverse, okay.
No. So what I'm saying is, when we did the redevelopment plan, we had no idea how loud, it was all conceptual, and we said there needs to be a sound wall to meet the state standards, and it needs to be at least 8, it needs to be between 8 and 10 feet in height. They're saying, based on their current studies, it needs to be higher, and I'm saying, then the board should grant a variance.
So you're agreeing with
I'm agreeing that,
him?
well, I'm not an acoustic engineer, but if he tells us to meet the state's regs, it has to be 22 to 26 feet high, then that's how high it needs to be. I don't believe the applicant would spend more money than necessary, so I just said,
Well, then do it.
in an abundance of caution, the board should evaluate that as a variance and then grant that variance.
Is that wall on any of these pictures, any of these plans, any,
It's not.
nowhere?
It's not. So that was one question.
That's what he said before.
Right.
Location is drawn on some
Well,
of
that's where my question
Well,
came from.
if that's what it has to be, I mean,
Right.
let's just move on.
It
Yeah.
has to be that to be state
Yeah,
compliant.
let's move on.
And we'll submit the design to Mr. Taylor's office. We'd be happy to do that as a condition of any approval.
If I may add, if maybe in the future with our redevelopment plans, we can just put per state regulations instead of a limit? That could be a consideration.
We can look at that.
And can we put a consideration in as well to comply or be consistent with the wall that's being built on the adjacent property with the new development? Will they not meet each other at some point?
They will be separated, you mean on the Marne Highway Blue Water site, they will be separated by the railroad right-of-way. I'm not familiar with the product you're talking about. I know that another user used a product called Plywall.
I mentioned that, yeah.
So I think we can work through something that sort of complements the building in color and style. And as long as the board is comfortable doing that. If the board wants to see that, then, that's sort of a different issue, but that would be the board's pleasure either way.
I think you gotta just do the best you can with aesthetics, given the dimensional requirements that you gotta meet. It is what it is at that point.
Yeah, you can't put a few shrubs to aesthetically.
There is also a significant landscape buffer requirement with evergreen trees that, as I think it was Mr. Webb indicated, are proposed on the outside of this wall to help soften that. The other thing is, in time, that will help grow and get even higher than the wall and create, sort of three-dimensional and sort of reduce the mass, the visual mass of the building and the wall.
How high is the building again? The building? 40 what?
46 feet?
So these are half the size of the building. So they'll kind of take a little of the impact of the building away anyway, right? No. That's what they got to do.
Sorry.
We go sit? Thank you.
Thank you.
Last thing we have to talk about is actually the appearance of those buildings themselves. So if I could ask our architect to just come forward, David Schmalk, and just show you the buildings and the design and the materials. I know we've got a couple of comments in the design group letter that we've got to address too. You have been sworn. Again, just briefly give the board the benefit of your qualifications and your experience and your authorization to give a testimony you're about to give.
David Schmalk, SCHMAUK. I'm a principal and owner at Wolf Architects. I have a Bachelor of Architecture from the Pennsylvania State University. I am NCARB certified and registered in 7 states, including New Jersey.
We ask that he be accepted for purpose of architectural.
Have you testified before other boards such as this?
I have testified in many other boards in New Jersey. I have not had the pleasure yet of testifying here.
Okay. Any questions from any board member? Okay, you're acceptable.
Thank you.
Go right ahead and describe the buildings that you've designed.
Okay, just give me one quick second to figure out which renderings we got here. There we go. We're up to A6.
A6, yes.
Okay, I'm going to mark this exhibit A6.
And you're showing an aerial rendering of both buildings, correct?
That's correct. This is an aerial rendering of what we call Building 1 and Building 2. The one in the foreground is the larger building, that's Building 1, that's approximately 280,000 square feet. And the one in the upper right-hand corner is Building 2, that's approximately 180,000 square feet. And this is obviously looking roughly from Route 38. Run through them? Sure. I'm going to mark this Exhibit A7. Again, this image is looking roughly from Route 38. The building in the foreground is Building 1. The background to the right is Building 2. The significant element to point out in this building is that as per the township's request, we've added to what is the standard Black Creek Group's aesthetic, and we've put a faux entrance on axis with the entry in order to break up the length of this facade and create a focal point, again, on axis with the entry. So I'm just going to move on to the next image that'll show that in a little bit more detail.
And just one point for clarification for the board. The building in the foreground on the right-hand side is actually potential future commercial. That whole area is going to remain wooded, correct?
Yes.
Correct.
Yes.
Right now.
Yeah.
So that's the view at the Lawrence Boulevard, Route 38 intersection. Correct.
When and if commercial development happens.
Right.
But that whole near side right parking lot and building will be
Right.
largely wooded.
This is an imaginary.
This is, yeah, potential future. The rest of the building is accurate, just not that front corner. Sure.
I'm going to mark this Exhibit A8. This exhibit again shows both buildings. The building on the right, though, that's featured a little bit more prominently here is a smaller building. That's Building 2. And again, you'll see that there is, and I'll talk about these in a little bit in a second, but there's an accent feature in the center of the building that came at the request of the township that we added in order to break up the long facade of the building. Okay, so this is going to be A9. This is looking, again, at Building 1 on axis from the driveway. This is an architectural embellishment roughly at the center of the building. This is not an entrance to the building. This is, again, something, a feature that we added to the building just to break up the facade. It has a higher parapet. It has storefront glass, and it has awnings on it. So again, it's just an architectural embellishment. The concept is also that at night, there's going to be accent lighting behind this glass, so this will light up and again just be a focal point as you're arriving to the building.
Those buildings are the 40-foot ones that we're talking about, right?
This building here is 46 feet at the high point. The other building's 43 and a half feet at the high point, and that's just because of the overall width of the building.
Could I just interrupt you for 1 second? And I'm sure somebody in the audience knows the answer to this question. That, we'll call it the new warehouse that's on the other side of Route 38? You know which one I'm talking about? How tall is that? Any idea?
About the same, probably about 46.
Okay, yeah, just get a conceptual idea, because that one we can see.
Yeah, about the same.
So you said it's about 46?
I'm guessing about
Okay,
That's typically industry standard.
all right, thank you.
These next two images, this is going to be A10. These next two images are largely the same. There are, as someone had testified before, there's 4 office spaces in each building. They're at the corners of the building that are right now shown as 5,000 square feet, which is typical. Each corner of the building, each building has an entrance at 2 of the corners opposite the truck courtyard. And this is the standard aesthetic for what the corner entrances look like for the Black Creek group. So you're going to see that this one that we're looking at right now is building 2, with building 1 in the background there to the left. But you're going to see that all of these 4 entrances look very similar, or actually look identical. This is, as we talked about before, this is a Class A building, which is very simply to say this is the highest quality building that you get for the building that you would build for a building of this type. We're using their warm earth tone scheme, so it's the warmer scheme as opposed to cooler colors. There's storefront glass at the entrance. There is, as you can see around the base of the entrance, there's stone on the facade. There's metal awnings, and then underneath those openings, there's accent lighting. So this is consistent with both of the buildings, and then this similar aesthetic is what we talked about that we created at the faux entrance. That is building 2. And the final exhibit of the night, A11. This is one of the 2 similar entrances that you'll see in building 1, and then you can again see the intermediate entrance that we created, or the intermediate architectural embellishment that we created in the center. The other entrance is at this corner over here.
So there were some comments in Mr. Taylor's letter. Scott, I don't know if you want to run through them, or I think we came to agreement on most of them, if
I
not all.
thought you agreed to all of them.
I think we probably did. My arm's still sore.
I think, and you will comply that any of the roof-mounted equipment will be identified and properly screened.
So the roof-mounted equipment, first off, they're relatively low. There's not that many pieces of equipment on the roof, but there are mechanical systems on the roof. They typically sit between 34 and 40 feet back from the roof edge, and they're only like 60 inches high, so and there is a parapet on the building. So they're only going to stick above the parapet between 24 and 30 inches. You have to go several hundred feet from the building before you even start to see them appear over top of the parapet.
And I think that, from a building design standpoint, that probably covers comments, from our report. I don't have anything else on that.
That's what we have for you in affirmative testimony. Sorry, we've talked a lot here as we must for an application of this nature. But that's what we have. We're happy to answer, obviously, any of your questions, Mr. Miller's questions, to the extent we have.
I do have a question, and I apologize, and maybe I missed it in your response, but the fire official had a concern about the location of the hydrants. Was that addressed?
I'm not familiar specifically with the comment, but I can assure you, we would agree to modify hydrants, either number or location, to the satisfaction of the fire official.
So the collapse zones. So I think the request was for them to be relocated to the corners?
That's fine, absolutely. Again, we will comply and work specifically with them to make sure that they're beyond the fall zones of the walls.
And are the colors negotiable?
I'm not the person to answer that.
Yeah. And I think the rendering is probably not fully representative, so I think hopefully through resolution compliance, we can work on final, actual.
Okay. Gotcha.
We'll show you, again, back with the sound walls, we can take you some.
Will the sound wall block any of the view that we're seeing here? It'll just be on the back side.
Sides. The sound walls will block truck work, really.
Well, I think Mr. Dottie's testimony was where the sidewall the sound attenuation wall comes along the western property line, it then turns, so this will actually be blocked from Route 38. I think it comes all the way down the driveway to the entrance drive, is where he marked up on the exhibit.
That's what I'm confused.
Here we go with that sound wall.
Maybe just to Main, maybe to Main Avenue.
Building from 38, the sound wall won't block any view from 38.
So,
Is that what he said?
Mr. Dottie, can you point to where the building is and where your wall's going?
We were just discussing, the wall would block some of the truck operations you're driving around. You're not, there's loading docks over there on the western side.
Isn't that where the entrance is?
Right. So the,
You're saying wall here? I'm sorry, I stand corrected.
That's what I thought.
He threw more wall on.
Yeah, I thought so.
I think as the report got done, Langen showed a little bit, and then I think as the acoustic all got done, it got extended, so. About the western quarter of that western building.
And that's closer to the residential area
entrance.
too, right?
Yeah, and it will help with
Main
that sound
Avenue.
attenuation. The only suggestion with whatever those changes are, that the landscape buffering to soften that sound attenuation barrier should also be sort of commensurate.
They're gonna need bigger trees.
That's from,
Well, he's gonna have a 26 wall there.
Anything else? I think we got it all.
Any other questions from board members of the applicant? Professionals are all okay with?
Yeah. They
Yeah.
said they're gonna answer all our letters, so.
Okay.
You know, Marty,
Mrs. Newcomb?
I just keep thinking about your comment about the DOT and the DOT, how, you know, everything's in their hands. But then I'm thinking, I go to Lowe's on the other side, and I'm sure all of us do, and we almost get rear-ended when we're
Yeah, I
trying to
think
turn
I'm
into Lowe's.
hoping to finish this
And then the
one because I don't
DOT
wanna
in
get
their
to the
infinite
11
wisdom,
o'clock.
if any of us have ever tried to go to Walmart down the road in Lumberton, almost get rear-ended going in there. And that's without any kind of real trucks trying to pull out. So, I mean, does the planning board have any oversight in what the DOT says
Walmart.
is acceptable, or is the
Not
DOT?
on Route 38,
No, so whatever the DOT says, that's gospel.
that's their jurisdiction.
And I'm not saying they're not gonna do the right thing, but again, I don't think they did the right thing at going eastbound to Lowe's or eastbound to Walmart, if anybody agrees with me or not, as far as how to get into those places.
Is that the bypass is a county road, that is
Right.
what it is. Two different entities of how they deal with things, believe me, been dealing with
Yeah.
it long enough.
Walmart's a state road.
That they look at things sometimes differently.
Oh, yeah, a lot different, like maybe they don't drive it. I hear you. But that's all right, these guys have done a great job, that's the only thing that really
Like I said, I asked them, when they're speaking with DOT, they asked them that specific question about a XL lane coming out of.
And listen, it's their tenants who are gonna, complain big time if they can't get their trucks out on the 38, I get it, but I just was a curiosity point to me. I'm sure that they're gonna address it to their satisfaction. but I just wanted to see something.
All right, guys, enough.
Okay, since there are no other questions, not that I'm shutting anybody down, we'll open it for public comment.
Mr. Chairman, if I may, Sir Brian, we haven't, the redevelopment plan has a requirement that talks about compliance with the provisions of the reciprocal easement agreement. And I think before we open to the public, I think it's probably proper to ensure how you guys are complying with those provisions.
Yeah, thanks, Mr. Taylor. We touched on that briefly with Mr. Fierro's testimony. So there's a reciprocal easement agreement between, I guess it's currently the portions of the Nissan property and the public house, the bar restaurant next door. The agreement itself gives the grantor the right to terminate the agreement by conveying a portion of the property, which is the parking area currently used by the bar and restaurant, to the bar and restaurant. I can certainly allow the property owner to speak to that, but I think what I'm saying is correct. But I do know that the easement is being terminated because these are simply incompatible land uses.
All right, so you will comply with the terms and provisions of that.
We will.
And this was actually addressed by this board in 2005 when the original dealership came in for a use variance. There was a subdivision that created a small 7-acre lot associated with this. Conveyance of that lot as part of the reciprocal easement agreement was part of the board's approval in 2005, as recognized in Resolution 2005-25. As part of this, that small wedge of what is now the eastern portion of the eastern Nissan property, Seagull Holdings, is being conveyed to that adjacent property owner to extinguish some access and parking easements. That had been reviewed during the redevelopment plan development phase. There had been a request by the adjacent property owner who owns the public house and the motel to include access driveways onto the new Black Creek driveway. That REA, that reciprocal easement agreement, was reviewed by Mr. Gillespie at the time, and it was determined that there was no obligation. There was an expression on the part of the redeveloper that having that commingled driveway was not desirable for them, to have people leaving the pub and accessing essentially where the tractor trailers are coming in off of Route 38 would not be appropriate. We reviewed it from a planning standpoint, and whereas if this was a handful of strip centers and commercial uses, kind of like we have across the street, we would always want to connect those where you have like uses, and you want people to be able to go from one shopping center to the next, so you don't have to go out always under the roadway. We evaluated this as part of the redevelopment plan that was adopted. It was specifically not included to facilitate any of those connections because of the differences in those adjacent uses. And for that reason, the Nissan site does not connect into this Black Creek driveway, which is a dedicated driveway for the industrial component only. And similarly, the extinguishment of that reciprocal easement agreement no longer creates a requirement for a driveway to connect to Black Creek, and it is not part of the current proposal. So this has been a topic of considerable discussion for over a year now with the various applicants and also the adjacent landowners. So we thought it important that this be part of the board's testimony. This has been an issue that the reciprocal easement agreement is dated, I believe, 1990, Bob, or 1991.
I think it's 1990.
And it's been the topic of much discussion and debate. So we want to make sure that this gets wrapped up cleanly, and the board and the applicants and all the parties are clear on what the expectations, what the requirements are of the redevelopment plan. That was the short version. Neil.
That was the history of it, yeah.
Okay, where are we? Storm,
One other under direct, I know that you had said that all trash pickups would be scheduled during daytime only. The second half of that comment was that deliveries would also be unless that is a 24-hour operation. And I know that this is likely going to be a 24-hour operation, but if for some reason it's not, and I think a lot of the adjacent uses, if you do get somebody who only is working 2 shifts, it would be really nice if all the deliveries could sort of fall into those 2 shifts. Is that something that can be considered?
My hesitation is that, as testimony was given tonight from a traffic standpoint, a truck could be coming for a delivery to leave at a dock.
And when it gets there, it gets there. Okay.
Otherwise, that truck
Right.
would be sitting on a road somewhere, you wouldn't want that either.
Right, okay. The second component was, you guys talked about, depending on the user, there could be a tremendously varied level of solid waste that can be generated, and you do have some compactors. Would you guys be willing to an ongoing condition that any future tenant is subject to provide compactors and/or pallet, recyclable and/or dumpsters to adequately contain and control solid waste and trash?
I think it's the same thing, any tenant has got to be in conformance with the ordinance, which means that they have to.
Right.
Have that stuff contained, maybe it's got to be signed, whatever your ordinance is. I just can't put the condition, because I don't know who that tenant's gonna be, to say you're gonna have to handle the material this way. But they have to handle it in conformance with the ordinance, which means it's responsible, it's contained.
So our redevelopment plan does require that, so I think it's appropriate to have that. And what I'm really trying to avoid is 3 or 13 years from now, some tenant saying, we don't know what you're talking about, we don't have to comply. That way, if it's in the resolution and there's a note on the plans, it's pretty easy for that operator to understand, hey, if I want to start doing pallet storage in the back, I actually have to do an enclosure for that, because we have a no outside storage requirement. Right.
So he couldn't do that anyway.
Right.
You had to go to those storage.
Okay. I think that was about all I had, Mr. Chairman. They did provide testimony on, I believe, the remaining items and agreed to comply with the comments of our November 23, 2021 report.
Okay, thank you. We'll open public comment. Anybody, public have a, okay, come forward, sir. And could you state your name, and Mr. Kingsbury will swear you in.
Your name first.
Ron Smith,
Ron Smith?
yes, S-M-I-T-H.
Okay, I can smell that, spell that. You swear or affirm the testimony you give will be the truth, whole truth, nothing but truth, so help you
Yes.
God? Thank you.
Okay, I live at 211 Ingleside Avenue. My property butts right alongside of theirs. Been there for 31 years, been in Hainesport for 43. I have a lot of concerns, a lot of them you already answered. Some of them I'm not quite sure where or this wall's going to go, but right now, the buffer zone,
What?
the buffer zone that they
Oh, okay.
propose. I don't know how big it is, what they're looking at, according to a little drawing that I have when I received the letter last year, it looks like a 10-foot buffer zone. That's the minimum, they say.
Now, are you talking about the buffer zone, or are you talking about the wall that we were talking
No, I'm
about?
talking about the buffer zone right now,
Okay.
okay? Right now, it's almost 60-some feet buffer zone that I have on the property from the existing operation that's there now. It's all wooded, it's all trees and everything. They're gonna come in and tear all that stuff out.
Can you show us where your house is, sir, on the plan there? I can't see, you're kind of blocked. Can you go, can you,
On the other side.
can you go to one way or the other, just so we can go a bunch of different ways?
Right there on this corner.
I see it, I see it.
Okay, I have an aerial view if you wanted to look at that too. But it looks to me like the trailers are gonna be 10 foot from my property line.
How could that be, Scott? Isn't there a
No, the,
75 feet minimum?
no,
The trailer's back there on that
50
side.
setback.
According to the print. Right here, the trailer.
Can't be 10 feet from this property.
Yeah. Give me a 10-foot buffer.
no, so,
I have almost 60-some feet there.
Get control of this guy. Needs to try.
when the redevelopment plan, when the concept was presented, the requested parking setback from a residential district was 20 feet. That is what was written into the redevelopment plan. That 20-foot setback is what's being complied with now. So it is compliant with the adopted redevelopment plan. As previously indicated, there is an evergreen landscape buffer within that area, as well as the sound attenuation wall.
So the parking will be 20 feet from his property line.
Correct, and between there will be the evergreen, largely evergreen buffer planting and the sound attenuation barrier.
So you're saying there's woods there, sir, now?
Yes, they've been there. I've dealt with this.
Do they feel like you need to take those trees out to do what you need to do?
I think we can take a look and see if
I-
they maintain them.
I wish somebody would have a meeting with me, come and see what I have right there now, so you understand what I'm talking about. You know, I mean, you're more than welcome to come up to my house and look at it and see what I have.
Do they have to submit a plan on taking trees out?
So they do. They have a note on the plan that the clearing limits need to be staked in the field and approved prior to construction. That way we can try to save some specimens. We can also, if the applicant's agreeable, take a look in this location to try to save some trees. If we have scattered deciduous trees, when you try to save only about a 20-foot width, that can look pretty stark. One of the objectives here was, let's try to get a predominantly evergreen planting with white fir, American holly, Norway spruce, and
Lower.
I think Colorado spruce that'll really grow into a thicker evergreen hedge. But I think if the applicant's agreeable, we can try to strike some balance and try to preserve some to the extent that the grading would actually,
We'll take a look at that.
right.
I'm also,
Can you see, sir, can you see the site that's there now through the trees? Are they higher?
well, they're high. In the summer, you don't see it. You don't see that site. Very little do you see.
And what was your address, Mr. Smith? I'm sorry.
211 Ingleside Avenue.
Thanks.
Here's a view from, top view, whatever. An overhead view, okay? My property line actually goes straight down through here on an angle. These people, whoever had it before, had the fence put up there.
This is where the facility is.
That's the facility, yes.
And that's all your land right here? This is all your land right in here?
Not right, well, right in here.
Whose land is this?
This is mine right here, but what happens is, this is part that goes on a triangle. They put a fence up there.
But this is you right here. This
Yeah,
is
that's
all
me.
you.
That's all me right there.
So they're saying they're gonna put some lower shrubs in here. But these have to be high with maybe some weeds and that thing in the
They're
middle?
high, they're high, that's looking down on top.
What kind of trees are they if they're high?
There's pine trees.
Not much room left there.
Yeah, you want,
Not a tree, actually.
I don't know if you wanna show everybody else.
Everybody else.
I don't know, you-
Mr. Taylor, you're going to take Mr. Smith's comments into consideration when you coordinate with the applicant on the landscaping, right?
We will. So I think the applicant nodded in agreement that they would agree to, A, look at their grading to try to save as much vegetation and perhaps do that in consultation with a site visit with Mr. Smith.
Okay.
That's fine.
Is that acceptable to you, sir?
Yes, sir, that's fine.
Good.
Another thing I have is these basins,
You might need that more than me.
filtration basins, from what I understand, it's like a pond. So what happens in the summer with all the mosquitoes in there from the water that's being collected?
I don't, yeah.
I can speak to that, sir. So the basins are designed to be dry, except during the storm event immediately thereafter. And the state has requirements on the duration that water can stay in that basin. They have a maximum drain time of 72 hours, and in fact, our basins will drain far earlier than that. So it's not going to be a permanent wet pond. It'll be a dry basin with a sand bottom in dry
Okay.
weather and immediately after.
What
storm.
happens when it clogs up and it does get?
We have an
2
obligation
years.
to maintain it.
Okay.
And to maintain the infiltration components of it. That's an obligation that will run with the land. The operation and maintenance agreement is part of our application package, both to the state, that ultimately gets recorded with a state permit that's going to be issued eventually by them. So, the property owner has an ongoing maintenance obligation.
Okay, that's some of my concerns, that's why I'm here. Another thing I have concerned, what's it gonna do to the value of my house when you pull up there and you see a 46-foot building up? The building's gonna be higher than the sound wall, it's gonna be higher than the trees. That's
I mean, right
the
now,
question
right
I'm
now,
asking.
you have
What
a,
would you rather have behind your house?
right, so polluted.
What I have right there is fine.
It's polluted, you have
You
a
asked, I'm telling you.
Well, the choice is the creosote plant
polluted, yeah.
or this warehouse.
I'd rather have the creosote plant because it's no longer a creosote plant for one, okay?
It's still
I'm telling you, what would you rather have? The warehouse behind your house, or would you want the creosote
I
plant?
think most sensible people would want the warehouse,
Or you think, I wouldn't, let me put it this way.
rather than
I wouldn't buy a house with a warehouse behind me. This is what's happening now. I bought this house, when I bought this property, the creosote plant was there, but it was way far away. Now, it's just a distribution property, that's all it is. The train brings the logs in, they truck it out. They no longer make the creosote. It was there before I bought it.
You know we can't answer that question.
Well, that's why I asked. But I had to ask you. So now what?
Talk to a realtor.
Yeah, right.
Thank
I'm
you.
asking, that's why.
I mean, I'm not being,
No,
you
it's a,
gotta talk to a realtor. I
it-
don't know.
it's a very, and it's going on a lot in town right now.
Yeah, I know.
It's going on a lot, going on all over right now. We've never seen development like this in this town. But these folks are sort of doing us all a favor by cleaning that site up. That's a mess over there. And I'm sure they're going to do everything they can to minimize the impact of it on your property. And Scott,
Yes,
Scott
that's
from
why
the
I want
direction
you
of the
to come
board
over
will
and
do.
talk to me. I'd rather talk to you personally.
Well,
you know.
you've been very, very nice, and we appreciate it, and everybody's going to try to help you there, but,
I appreciate it.
Okay, thank you, Mr. Smith.
you got to make the people want to help you like he's doing. Right?
Any other public comment?
Just a minute.
Yeah, wait, hold just one second. Are you coming for public comment, sir? Oh, I'm sorry. I didn't know whether you were coming or going, but yes, come on up. Okay, we need, Mr. Kingsbury will swear you in, we need your name and address.
Are you representing a client?
I am.
Okay.
Yeah,
Oh,
my name's,
okay.
This gentleman's an attorney, and I think he's representing a client.
I am. For the record, Jonas Singer, Wells and Singer, I am representing Durga Corporation. They are the owner of the property to the east of this project. Unfortunately, my client is unavailable this evening. He's in, I believe, Mexico with his son, who got married over the weekend. So his marriage was predated the notice that we received. But my client has been very active in expressing his concerns regarding this project. We obviously are not against the project. We think it's a good project. But we have, when your redevelopment plan came about, My client asked me to send a letter to the township, which I did, to your clerk, copies to your professionals, expressing our concern with respect to the new driveway, the new private road that is being built along the easterly property line, and with regard to drainage from our property. The concern is that our existing driveway is close to the intersection of 38. So cars will just pass our driveway before they even know that we're there. I did, by letter dated February 22, 2021, send my initial letter to your clerk and to your professionals. I followed up with another letter of March 1, 2021. I followed up with another letter of March 3, 2021. And, you know, I heard your planner indicate that we've had extensive discussions. We've had no discussions. There have been no discussions with the property owner. There have been no discussions with myself on behalf of the property owner. I've never received a phone call from Mr. Gillespie regarding any facet of the redevelopment plan. And my request is that the board allow my client to present testimony from a traffic expert that I met on site this past week to present to you the concerns that we have with respect to traffic and the inability of access to our property once this cross easement is terminated. The cross easement was entered into in the early 90s. The then owner of the Travel Inn paid almost $140,000 to the neighboring property owner for the easement. But its terms do allow for the cross easement to be terminated after a certain period of time, and that time has elapsed. But the configuration of the property that is now the Nissan dealership is very different now because of your re-subdivision and your alignment of lot lines. So, you know, I haven't sat down with a planner yet or an engineer, but, you know, there's a question in my mind as to whether the cross easement can be validly discontinued. I'm not saying it can't, but, you know, everything has happened so quickly. The first notice that we received of this application was last month in November, and again, fortunately or unfortunately, it was the equivalent of the Indian Christmas holiday, and so my client wasn't available at that point. But we have had no opportunity to retain experts to present to both this board and to DOT with respect to the access permit that is pending as the applicant has indicated. So at the very least, I would ask that this board continue the meeting to allow for the neighboring property owner to bring in its experts to testify as to the health and safety of the traveling public, because once they pass our place, then they have to maneuver and go around the various jug handles to come back, or we lose the customer itself. There was a request to allow us access off of this private drive so that we could at least come into our property. We don't have to come out of it. We just need to get into it because, again, we will pass the existing driveway going east, going west on 38. Sure.
Just educate me. What obligation do we have, a Hainesport Planning Board, to consider your site in Lumberton? Is that something that's traditionally done? I wouldn't.
Part of our property is in your township.
Is it?
Yes.
What part?
Well, the easterly portion of the property. There is this portion of it.
There's a building on the
I don't believe the building is. I believe it's the parking area that is.
The parking area is in
Correct.
Hainesport.
But I don't
Is that
think,
something traditionally that happens, where another town would necessarily hold up a project for an adjacent property in another town? Or-
well, I think they're
I'm just
adjacent.
asking. I don't
They're
know.
adjacent neighbors, so I would think that
So-
your concern with
Neighbors?
respect to the health and safety of your residents doesn't stop at the property line. It stops, because we are, in Lumberton as well, shouldn't diminish your concerns as to whether this is a safe.
And the easement you're seeking is in Hainesport. The easement that you're looking to continue is in Hainesport.
I'm not looking to continue the easement. I understand that the cross, that's a matter of discussion as to whether the cross easement can legally be canceled or not. But I am looking for, yes, I'm looking for a short easement, because the road itself, the driveway itself exists. The entrance into our property presently exists. So there would require no improvements off of their property. And it's really within the first 15 feet of their private road from, coming off of 38th.
So it's not a private road, you're aware.
I'm talking about the
It's a-
proposed
it's-
private road.
No, it's a driveway.
Well, okay, it's a drive, well, fine, it's a driveway.
I'm just saying, under the land use law, there's a distinction between the two, and I just want the
No, okay,
record to be-
I'm correct.
I mean, I can remember being on the board, I think Tom was, when Mr. Hester came in and wanted part of his Nissan parking to be able to cross the Creosote folks' driveway, and they agreed, so they could at least get the cars back and forth. Did your easement have anything to do with that?
No, our easement is further east, adjacent to our property.
And it now goes on to the Nissan parking, if you will, that's
Oh, yeah,
there now.
it's exactly, yeah, it's in the Nissan parking area. It allows us to park tractor trailers and automobiles on their lots.
So how do you, again, I pass it every day, but when these cases come up, it's hard to visual. So if I'm coming west on 38, I can turn into your establishment on your land?
Our only driveway is about 50 feet from our property line, from the easterly property line. So if you're going west, there's not much of a sight that you would see, especially if you're going through a green light at the bypass. Okay, now you have Starbucks on the corner. Their fence comes out almost to the road, and so there's very little opportunity of slowing down and turning into our property without the cross easement.
So what do? They go past your entrance and pull in through the Nissan property, if
No,
you will,
no,
that
right-
angled driveway? Is that what they do?
Right at the end, and it's on the site plan
Yeah.
of Langdon.
Counselor, could you show us on the?
Sure.
What their exhibit is? I think the next one, the big one, would be,
It's none of our business, is it?
Okay, so here's the bypass, you're going west on 38.
Right.
Starbucks is on the corner,
Mm-hmm.
and the driveway is right there.
Your driveway.
My driveway is going into the right
Now, don't they have the driveway before you is Starbucks? So they even have less time to make the turn into Starbucks, right?
Well, Starbucks is on the corner.
Right, but that's like that far from the light, if you will. And you're even farther,
There's
right?
visibility, you see it coming up.
Okay.
But now there's a fence that crosses the back of Starbucks, and so when you miss our driveway, the next driveway is literally at the corner, at the property corner.
Right.
now that red line that's on that exhibit, that's the Lumberton Hainesport?
Correct, this is the lumber.
So what you're talking about is in Lumberton?
Yeah.
Yeah, this driveway's in Lumberton.
Yeah, I understand that.
Correct.
Right.
And so going back to a comment that was raised before, why is that my problem?
Really?
Yeah, the driveway easement he's talking about though is here.
It's in Hainesport, right?
No, the drive,
Existing.
The existing easement
Is
that
it
will be
a-
terminated
Yeah.
is this.
correct.
That's his driveway to the motel.
Well,
This is the easement that's to be
I mean, the-
terminated. Because of the new driveway, put it side by side.
Your client just wants to try to leverage their development so he can get a backup entranceway.
There you go.
That's the bottom line.
There
No,
you
it's
go.
not. No, it's not. If you,
That's the way I see it.
well, no,
Me
listen,
too.
we understand the importance of this project to your township. There's no doubt. And I'm not standing here objecting as an objector to the project. I understand the process. I understand it's part of your redevelopment. We obviously accept all that. But we have not had any opportunity of presenting any testimony before this board as to the need for the additional entrance to our property.
You're testifying now.
You just told
I'm not testifying, I'm
We
asking
don't
for.
need a traffic control.
Oh, I do.
That's lumberton.
You just told us the need. The need is your client wants a backup entrance.
Yeah.
It's not a backup entrance, it's a safe entrance, because the one we have now, other than, once the cross easement is extinguished, is unsafe.
So can I,
What's unsafe about it?
It's too close to the intersection.
So if I may ask,
Starbucks.
when Starbucks went in, did they come to you and ask for
I-
cross easement?
I was not,
When people passed Starbucks accidentally, did they ask for people to have the opportunity to make a right into the public house or into the hotel to cross over?
I'm not aware of that.
Okay,
So-
so I would like to address that your client did receive notification when this redevelopment area was studied. He
Correct.
also received notification of the redevelopment plan. And we
Correct.
did meet, in fact, on February 8th.
Okay,
I met with Mr. Patel as well as his son. Lovely people. We had a wonderful conversation. We also met with our planner, Scott Taylor, and discussed this. Now, we can't speak to any conversations that you may or may not have with private entities.
Well,
That's
I'm
not our water.
I'm not looking for private entities. I was just looking for some response to correspondence that I sent in, but be that as it may. So that's one issue. Second issue is that we have an existing drainage easement crossing into the Nissan property. It's shown on the site plan. I received a phone call from counsel for the applicant on Friday saying, we're going to move your drainage to the new site, and we're going to run your drainage to one of the retention basins that we're going to be constructing on the warehouse site. I have an existing easement. I have an existing drainage easement onto the Nissan property. Why would I be required to terminate my existing easement?
Well, aren't they gonna continue your drainage, just move
Yeah,
it
but
to a
that's not-
spot on their property that
but-
works?
Do you have a reference on that easement, a deacon page on the filing?
There's
on
a
the
filed
specific-
map
on
that,
the-
it shows up on their site plan.
And it's a specific easement?
It shows up it's part of the filed map. Obviously, they picked it up because it exists it shows up on their site plan.
There's no easement. There's no easement, there's just the drainage.
There's a pipe.
There's a drainage easement running from our property to a retention basin on the Nissan property.
I've never seen the easement.
Well, it's part of the filed map. How did they pick it up?
No. The physically is there. I never seen a recorded easement.
It was on the filed map.
On a filed map?
Yeah,
Which
that's how they picked it up.
Which filed map?
I don't have the map reference. Again, this is, county clerks, I don't have to tell you about the county clerk.
You
It's
should have
closed.
brought that map if you want us to
Well,
consider that
because
testimony.
I can't get into the county clerk's office.
Why
okay?
not?
Because COVID, they're closed, okay?
Okay.
They're limited.
Send you a copy of it?
No, they're not.
No.
What?
I will get it.
Can I just?
But again,
can I
this,
just-
all of this,
Can I just ask our attorney something?
sure.
Because it's late, and I appreciate you coming and all that. Bob, what concern is this of ours?
I don't see how he can, well, two issues. If they deal with your drainage, why do you care how they do it, as long as they continue to do it? They've agreed to
It's not-
handle your drainage. You want it through a specific pipe and you're not willing to change
No,
that?
I don't know how they're dealing with my drainage, okay? I haven't had an opportunity. I received a letter Monday from the applicant's attorney confirming that they were going to deal with my drainage, okay? I should have an opportunity with my engineer to review their drainage calculations to determine whether
Then you-
they're going to deal with my drainage.
I think you should work that out with the
Well-
client and not, this board doesn't have control over what.
But their
how they
plan,
drainage.
their file,
All right, the second issue is the easement, the existing easement. I read the easement agreement. Mr. Gillespie read it. We are both in agreement that it can be terminated under these circumstances. I don't think this board can impose an easement on the developers that are in front of us right now.
Well, why would,
If they have a right to terminate it, and that's it.
I understand, Kingsbury, I understand that, but why, on the other hand, can this board impose me, my client, directing drainage to any place other than where it's going to now?
Well, I don't think we're imposing, we're just not considering it. I mean,
It's part of it's a part of their site plan. Their request, it's part of the site plan to show that pipe from our property back to.
Again, well, I'm going to defer to our professionals. I mean, if they agree that it's addressed, to me, it's addressed.
Once that pipe crosses their property line, what the hell do you care where it goes?
As long as it's taken care
They're
of.
just tying one and two together.
Met with Ms. Costco and Mr. Taylor back in February. Did he not disclose to you before Monday or this evening that he had met with the town in regards to this easement?
Oh, absolutely. And my correspondence post-dated his meeting.
But you started off by saying that
Right.
he had never spoken to any.
Well, I was unaware that he had any meetings with
Yeah.
either of you.
And he was very clear at that meeting that the stormwater easement will remain, and if it's moved, that it will be accommodated. And that statement was made, and he responded yes.
Well, because he expected that the stormwater, right now, there's a catch basin in the proposed private driveway. Okay, so he was concerned that that catch basin be moved outside of the driveway. That's what he intended.
That's not where the water comes from his site.
It comes, well, it comes from his site.
No, there's a drainage flume that goes under.
Correct.
That second inlet is being converted to a manhole. So nothing has happened to where the water flows into their pipe. Instead of the pipe going this way 300 feet, it's going to go that way 300 feet. In compliance with the stormwater management regs, they've accommodated that.
And that infrastructure is going to be completely paid for by the applicant as well as maintained with absolutely no cost to you, with the exception of you agreeing that there will be no additional accumulation and there will be no sediment or pollution. I think that's a pretty fair
Yeah, but that's, but
Accommodation.
until this past,
Memorialized in an easement.
in a new
yeah,
easement.
but I haven't, listen, the first time I heard this was Monday. Well, I take that back. Mr. Floyd called me this past Friday, okay, left me a voicemail, and then I received a letter from him on Monday. That's the first time.
Well, you were on the
2
call
days.
last month as well.
I was on the, yeah, but for the subdivision. But there was no site plan issues, there was also, it was strictly subdivision plan.
Again, I don't think, from what I'm being told, your matters for us. I think it needs to be worked out outside of this board. And it also sounds like our administrator and the applicant have already addressed the drainage issue. I don't want to tie 1 and 2 together. The easement to get in and off your property is, it sounds like it's over.
Well, okay. I respectfully disagree, but I understand your opinion.
Well, it's not our, I don't see where it's just from a common sense, I don't see where it's our obligation to provide you with an easement.
Well, I understand, because my property's outside the township?
No.
Not necessarily.
No, that driveway would actually be in violation.
Not necessarily.
Yeah, not at all. Because that property, the redevelopment plan, you have a copy of this, correct?
do.
That was, introduced in January.
Yes.
And adopted in February, and I believe Mr. Patel had a copy of this in February. And you said you just learned that the driveway is not,
No, I didn't just learn.
Oh.
I've expressed it since February 22 of 2021.
right.
Okay, and, but, I heard you indicate to the board that, you've had extensive discussions over the last year regarding this driveway, and I'm
We
saying,
have
well, with whom?
With both applicants' attorneys. We've had it with Mr. Patel.
Well, you had it in early February of '21.
Right. And the comment that I will make is, and this is what the attorneys reviewed, your client is being given 0.7 acres, correct?
It's part of the termination of the easement, in exchange for termination. So he's not it's
I'm sorry.
consideration for termination,
I'm sorry.
correct?
Your client is having 0.7 acres conveyed to him.
Correct.
From Seagull Holdings, the Nissan dealership.
Correct,
To extinguish an easement.
correct.
So therefore, you agree that the easement is extinguished?
No, I don't agree with that.
Oh, you just said correct.
No,
I said
you
it's
asked me-
being
You asked me if
conveyed.
there was a conveyance. I said, yes,
I
there is a
said it is
conveyance.
being conveyed to extinguish that
That
easement.
is part of the terms of the easement, correct? Of the extinguishment of the easement.
Right.
Has that happened legally yet?
No, it would be
Yeah.
a condition of this approval. They
Oh.
actually have to convey that land to extinguish that easement. And that is a requirement. We very specifically, because we knew this issue had come up, we had very specific language that was written into the redevelopment plan that it has to be. I think, in my opinion, if Durga Corporation wants access to this driveway, that is a private matter. They can discuss their own easement. I will say that even the conveyance of that 0.7 acres to Mr. Patel and Durga does not give him any rights to use that land because he has no municipal approvals for that land. So he may have an easement with Seagull Holdings or their predecessors in title that say we can park tractor trailers there, we can park other cars there, but he has no municipal approvals to do that. So what I will say is the conveyance of that land, which extinguishes the reciprocal easement agreement, would also trigger for Mr. Patel to do anything with that property, him to come back to this board for site plan approval, and if necessary, DOT approval, because he's expanding or changing the use of a property that fronts on a state highway.
Well, we understand that any future development requires board approval.
Right.
That, and DOT, that's not the issue.
Good. So I want to make sure we're
Well, no,
clear on
yeah,
that point.
We understand.
How do we get down the road? We're almost at the end here with giving away this 0.7 acres. And all of a sudden, this is coming up. I mean, did Mr. Patel accept the fact that he was gonna get this property? I don't even, why'd they even give it to him? I mean,
Well, it
it
sounds
just
to
works
me
for
that
them to do it?
Mr. Singer is now questioning that the conveyance of the 0.7 acres to Durga Corp. does in fact extinguish the easement.
No, I'm saying that if the easement is extinguished legally, then yes, there is conveyance of that 0.7 acres.
Okay.
But I'm not convinced that, I'm not conceding the fact at this moment that the easement can be extinguished without further proceedings.
How does this board deal with that?
Well,
It's
Right.
outside of that is outside of your purview. I agree, that's not your, my issue here
So what's
is,
the point of your having to present testimony to us
my point is,
regarding that easement? when
No, I'm not
there's
asking you-
nothing we can do about it?
I'm not asking to present testimony regarding that easement. I'm asking the opportunity to present testimony from a licensed traffic expert with regard to the traffic coming off of 38 and how the maneuvering and the safety of coming off of 38 onto my property without access off of this private driveway. And, okay,
You want this board to force the warehouse applicant essentially to give you a different easement than the one you now have?
Correct.
That's what you want.
That's,
So you can
I
have
have
a
a
backup.
suggestion.
Oh, let me
Why
finish.
don't you move your driveway from where it is down the road?
well, if, I don't know if DOT will let me. Now I'm going to be adjacent to their driveway. So I don't know, listen, I'm not an expert in traffic. I don't know if there's a distance between two driveways or not.
There's a lot of
You know,
one-way.
so that's another
There's,
issue that I
if you
need
go
to
down
explore.
38, there are multiple one-in, one-out access points along that entire commercial corridor. Starbucks has one access point on 38. You go by it, you have to go all the way around to the Lawrence Boulevard jug handle and come back around.
But doesn't he have a big sign out front that
Yes.
signifies where they're going, and he says that that you're gonna blow past it?
You can't
Am I
see,
missing that?
if you're driving 50 miles an hour on 38 going eastbound,
Then you go around.
Gonna apply to
You will
Lumberton for a
not
bigger
see it.
sign.
Then you
won't see
just
it.
loop around. You miss it.
Well-
Maybe you need a new sign.
Right.
It is now midnight.
All right, in the interest of time, mine, I think we gotta move on, okay?
Okay, just for the
And-
record, I'd
I'm
like to
not
just-
being disrespectful, I
I understand.
appreciate your
I-
concern, but 90% of what you're talking about is not my problem, it's not in my town.
Okay, I'd like to, just for the record, present to your solicitor the correspondence that I referred to on the record,
We have.
so we can, so the record's clear as to what I was referring to.
I think I have the.
Okay, where are we? Here, poor thing. He better come in a little late tomorrow.
I need the two, what do we do with regards to this other case? It's after 11 o'clock.
It's not new business, is it?
Pardon?
Continue it till next meeting.
Okay, but I have to do a motion and all that other stuff, all right. Any other, sir, you had a question, public comment? Yes.
Yeah, there's,
That we need to hear?
oh, no one's unmuted.
We're still here.
Yeah, we're still on it.
Sir, your name, please.
Chris Klezix, Klezzics.
Chris,
Yes,
C-H,
CHRIS, yeah.
you swear or affirm the testimony you will give will be the truth, whole truth, nothing but the truth, so help you God.
I do.
Have your address, sir, please.
1015 Main Avenue.
Thank you.
Sure. A lot of things have been addressed tonight, so I just had a couple questions. I was here last month when you guys were talking about the other warehouse. So I know the lighting, it seems like everything's gonna work, but I know this gentleman here mentioned something about dimming the lights at night. Is that a possibility to do the same kind of thing that you're doing with that warehouse?
So we did, and we had a comment in our report, the applicant, we wrote several things into the redevelopment agreement to try to minimize those impacts. We made additional comments. The applicant has agreed to comply.
Okay.
They will be putting house side shields on. And I think we also had a comment that to try to reduce them after hours if the businesses are not in operation. And I assume that the applicant would agree to comply with that.
Okay.
So do you,
All right, thank you.
Maine, is it
I'm right next to.
findable on that map?
I'm right next to Ron. Yeah, I'm right here. I'm the last house on Main Avenue.
Okay.
Kind of right
Behind the
behind
The apothecary.
the apothecary.
Yep. I know you mentioned the sound barrier is going to be 22 feet high, and there's going to be different elevations. Is there a way that we can see where the elevations are? Is it going to be 22 feet behind our house?
We'll give detail of these
Okay.
things to Scott.
Okay, all right. I used to work in a warehouse, so, yeah, this is back 30 years ago. So I know back then, they used to have outdoor communication. I know today with the times, it's not really happening, but I just want to make sure there's no type of speaker system that's going to be blaring out, outside that's, that's fine. Okay.
So you agree that there's no outside loudspeaker system or other aging?
Okay.
We have to conform with the noise ordinance.
Right, okay, all You mentioned the compactors. Is there any way to locate them on the northeast side of the building, away from our houses?
Again, it's gonna be driven by, well, we'll be on the truck court side of the building.
Mhm.
It's gonna be driven by units operations, so,
Okay.
and how the flow's gonna go through a building and
Mhm.
just,
Okay.
but they will be on the truck court side.
Okay. I know Ron mentioned about the trailer parking, that's gonna be pretty close to his house. I'm basically just asking what purposes, I imagine that's just for overflow. I guess that's what they're there for, because it is pretty close to at least his house, so, you know, that'll affect me too with the noise of them backing up with what you mentioned about the beeping and all that, so, like I said, I guess that's basically just overflow. And there's no way to.
That's what I see, that's the wall, again, the wall is used,
Okay, all right. So, the jump handle that you're proposing, is there gonna be any type of barrier, on the outside as you're coming into the turn? The reason I'm asking is, I showed you where I live. Today, drivers are pretty crazy, they're, you know, out of control. It's pretty easy for them to drive right through that jump handle into my property, into the house, whatever. You see they have it on the news, it's, you know, it's out there, it happens.
The driveway will be done according to the DOT standards. Generally speaking, they're 10-inch curbs, so it's unlikely that a car would be driving through that curb, but strange things happen from time to time.
And that's why I'm bringing it up, because, you know, we've all seen it, you know, you've all seen these crazy drivers out there, and, you know, we do have kids that are in the area, so, you know, we want to protect them too. You mentioned that you're starting construction June, July. As you can see, it's a pole yard. They do pick up dust. What are you guys going to be doing to minimize that dust as you're building?
control, GC, contractors required to do dust control.
Okay,
Dust control.
okay,
And dust control's controlled by the Burlington County Soils Department.
okay. All right. And tractor trailer drivers, you know, we don't know who they are, we don't do background checks on them. Is there any type of security going in your building? Because we've had people, you know, walk through the pole yards, and, you know, I've had to put cameras up in my house, so, you know, as I said, we have kids in the neighborhood, we want to protect everybody, so is there any type of security that's going up in this warehouse? Or is that for the tenant?
Tenant driven.
Okay.
Again, now, with the sound attenuation
Mhm.
wall, we're essentially fenced.
Mhm.
And I don't think anyone's going over the top.
No, I don't think so either, but, I mean, they can walk around and go through, you know,
No, I
that
understand.
drive, and, you know, like I said, my house is right there, so there's no reason why they can't walk a few feet to get to it, so.
Do most of these users have security?
Most. No, I wouldn't say most. No, no. I mean, a lot of it's, you know, fairly, I would actually say fairly.
Well-
When the security comes in, is more, as with some of the testimony before, is sort of fencing in truck roads.
Right.
So it's not security at the front, like where a car comes in and the car parking, it's more at the truck court area, securing traffic, securing inventory.
That's right, and I'm familiar with warehouses, a lot of them will have, you know, trucks backing up, so one truck driver, one truck company hits another trucking company, they want cameras everywhere, you know, just for their own accident, of that nature. Destroying your building, backing
And,
up.
and that's actually what I meant, not a manned security area. I just mean like security
Yeah.
cameras.
Yeah.
Yeah. Most of them, right? Yeah, okay.
Okay. And basically, just one last thing. The traffic is bad now, as you know, with the Starbucks and everything else going up. So yes, that's just a concern also. you know, I come up the bypass, and I know if I don't get to the end of that fence, I know I'm not making those lights on the turn. So that was all, it's just a, you know, just a traffic concern. But other than that, thank you.
Okay, thank you. Any other public comment, or anybody online?
There are 3 people online,
But they're
in
not,
addition to Ms. Tyndall.
let me just get this cleared up. Yeah,
Is there anyone online that would like to make a public comment on this application? If so, please unmute.
Good evening. My name is Sherry Wells, trustee with Christian Faith Assembly Church, 810 Martin Highway. I know when we proposed to put low-income house on our land, that we met with the surrounding neighbors. We invited them in to sit down with us before we came to the board.
Ms. Wells?
So maybe that's something that needs to be done beforehand, so that it wouldn't take so much time, you know, while you're there with the board.
Ms. Wells, I'm sorry, I don't mean to interrupt, but Mr. Kingsbury needs to swear you in.
Can you hear me all right?
Yes,
Okay, do you swear or affirm the testimony you give will be the truth, whole truth, nothing but the truth, so help you God?
I affirm.
Okay, thank you.
Thank you. I was just proposing that maybe the company who was there tonight could meet with the surrounding neighbors with the concerns. We did the same thing when we put a proposal through for the low-income housing on our land. We met with the surrounding, we opened up our church for surrounding neighbors to come in with their concerns before we came to the Hainesport board, so that it just minimized the issues that's going on tonight.
At this point, Mr. Chairman, the redevelopment plan, as you know, has been through a public process for its adoption. The site's been designed in accordance with that redevelopment plan. At this point, we're hopefully nearing a decision by the board, and we really don't have time to do that. I think that that process would or could have been incorporated into the public meetings prior to the adoption of the redevelopment plan and the finding of area in need, and would result, frankly, in requested changes that we couldn't agree to, having already designed a site and having it before you for hopefully approval tonight. I appreciate the sentiment. I've done that myself for many, many, many development applications, especially where something like a use variance is involved, where you're asking for something that you're not allowed to have. But here our application is by right, and I don't think that anything fruitful would come from additional meetings at this point. So we'll respectfully decline.
Can you confirm that they did receive notice of, they were within your notification? Are you able to do that? And second, I think that the timing has probably made this quite a challenge, because Mrs. Wells, your application was just recently approved, and during the planning process for this particular project, I don't know that they were even aware of yours as well. So I think the timing was a bit of a challenge. But you and I, if you want to meet, I would be more than happy to meet with you and the church to go over the project, if that would help.
I appreciate that. Thank you so much. Because we do have concerns with the height of the building, because it seems like we're being surrounded.
Okay. Sounds like a plan.
Thank you.
Okay.
She did receive notice.
Okay, thank you.
okay, sir.
And we did, and if I can follow up, Mr. Chairman, we did note that in our report that that has been approved, and that under the terms of the redevelopment plan, that residential buffer will, should be addressed, and then the applicant has agreed to accommodate that future residential use.
Okay, thank you.
Charles Bloom,
Name, please?
Charles Bloom, BLOOM, 204 Ingleside.
E-L-O-O-M.
Yep.
Sir, do you swear or affirm the testimony you give will be the truth, whole truth, nothing but the truth, so help you God?
I do. I just have a couple of quick things, nothing really major. So with the noise complaints, from what I gathered, we contact you if there's anything I'm not really sure who we, wow. So you'd be, with the decibel thing.
Well, as the enforcement, as the zoning officer, the complaints come to me.
Okay.
They don't all affect me, per
Because
se,
it's
but
goofy
I
with the
go
state.
back and- I go back and take a look at the resolution, what they're approved for, the minutes, and what our ordinance and redevelopment, and
Okay.
all the
Because
rest ordinance.
it's goofy having the state police says that you don't really feel like you have a local police force to be there right away to, you know,
Well,
if,
Telephone, you and I have been dealing with each other for many, many years, so you know where my office is.
I know. Oh, I like to annoy you any chance I get. And as far as the train goes, I know they said that they're not sure if they're going to be using it, but they're probably not going to be using it at first. What's going to actually happen with the land that the train is on?
That's Conrad's property.
It's just going by Conrail,
I
so
don't-
if it,
I don't think that's our issue.
okay, yeah, because I wasn't sure, because if it doesn't get used in a certain amount of time, I know when it goes past my house, because I'm right at the tracks, and it's noisier than, I'm sure that's where the 83 decibels is coming at the one point on there. If it doesn't get used for a while, does it, if the warehouse does decide that they do need it for something, is there going to be some sort of sound barrier that Conrail's going to have to put in if they're going to do all hours of the night with deliveries?
That would be addressed. The applicant agreed that if at some point in the future they ever want to do rail access and siding,
Okay.
that they would have to come back to the boards for an amended site plan approval. So I think rather than guess now, that would be something that we.
Okay, so if there is anything with the train, it'll just be down the road, not even.
Be down the road because they'd have to create a break in their acoustic barrier.
Right.
There-
Yeah, that's why I'm
There'd
just
be a
figuring.
number of things. So the testimony was, it's not part of this proposal. They'd have to come back for an amended site plan at some point if they ever want to use that rail siding.
Okay, like I said, nothing really too major, just a couple things to note. Thank you.
Okay, thank you. Any other public comment? If not, I will close public comment. Any other questions from board members or?
So if we were to consider the application for approval, would we need to put that variance in for that sound barrier? And to get back to
You're talking about the height?
yeah, the height, there seems to be a discrepancy. I apologize for getting it backwards.
No, that's okay.
It was so dragged out, I forgot what we were talking about. The next thing is, I'm still, I mean, I'm really happy that these folks came in, and of course, we met in subcommittees, and they know I was for their project. But this exit on the 38, again, you say, Marty, whatever the state decides is done.
I asked the applicant to, when they're still continuing the negotiations with DOT, to ask them specifically about a access lane going out of.
Yeah, and I believe I mean, obviously, they have to, but I believe that, from what we heard tonight, that they would certainly want to do things correctly. So I won't make that part of any proposed motion that I might make. So I am prepared to make a motion, Mr. Chairman, if,
Okay, let me just check. Any other comments from professionals? Mrs. Newcomb?
No, sir.
No? Okay. Yes.
I will, Mr. Chairman, make a motion to approve the preliminary and site plan with a variance for the
Preliminary and final.
preliminary and final. And that, we can grant them a variance right now for that
Yeah,
sound
you can include
barrier? Okay, so that's my motion.
So variance on the sound attenuation wall to exceed the
Which
8 to 10
I don't
foot
think any.
standard that's written in the
Yeah, we
redevelopment plan?
addressed, yeah,
Right,
State requirement.
as needed per the state requirement?
Yes.
sure.
Okay, so we have a motion on the application. I need a second. Okay, Mr. McKay, thank you. Any questions on the motion? May I have a roll call, please?
Mr. McLaughlin?
Yes.
Mr. McKay? Yes. Mayor Gilmore?
Yes.
Mrs. Kelly?
Yes.
Mr. Tricocci?
Yes.
Mrs. Baggio?
Yes.
Mrs. Tyndall?
Yes.
Ms. Cosco?
Yes.
And Mr. Colpfeffer?
Yes. We made it.
Chair, may I make a request? to amend the resolution to include, or amend the agenda to include resolution number 2021-22 with regards to adopting findings and recommendations to Hainesport Township Committee following review of the new zoning ordinance.
Yes, you may. Need a second on that motion.
I'll second.
Okay, any questions on the motion?
It's amending the agenda.
Roll call, please.
Ms. Costco?
Yes.
Mr. McLaughlin?
Yes.
Mr. McKay?
Yeah, there was no other
Can you just hold off on the... Excuse me, not the folks from the applicant, but some other people, the public. We have other business to take care of after this, which will go to public comments about anything you want to talk about. I just don't want people to get frustrated and leave, okay?
I got a 1-year-old and an 8-year-old
Okay. All right, I'm sorry, continue.
Mr. McKay? This is to amend the,
Oh, yes, then the agenda.
Yes, sir.
Yes, yes.
Mayor Gilmore?
Yes.
Mr. Cochi?
Yes.
Mrs. Kelly?
Yes.
Mrs. Baggio?
Yes.
Mrs. Tyndall?
Yes.
Mr. Colpfeiffer?
Yes.
Can I just make a comment to the applicant before you guys leave?
Well, we can do that under resolution.
Awesome.
You know, we didn't have a big outpour and a public outcry for your project, so I just hope you, and I think you're gonna, just help those guys a little if you can. I mean, I'm not looking for you to spend any money, you know. But you sound, yeah, thank you. I appreciate it. Yeah, they were very eloquent and very nice, and
Yeah.
that's a big project to not have an audience full of people, but
Oh, yeah.
thank you. We appreciate it. Thanks.
Okay.
Okay, Seagull hold.
Now, do we do the motion to continue Seagull to the next meeting now, right?
Yes.
Okay.
Wait.
Could I be heard for a second with your indulgence?
And what, about what?
I'm representing Seagull.
Oh, okay.
Okay, and I apologize, but my client has obviously gone to considerable expense with 3 professionals here. Our application will be no more than 10 or 15 minutes. I assure you, we have no issues with anything. Is there any chance that, I know you're going to be doing other things, that the board could please indulge us and hear this tonight?
We're here.
Mr. Eisner, I've looked at the paperwork on this. I don't think it's going to be 15 to 20 minutes. There's a lot of questions on the variances that are requested, some of the other issues. So I also think that it's perhaps a little unfair to the community, because generally we advertise no new business after 11 o'clock, so there's no public here. So when we ask for public comment, if we did, that would sort of deprive them. So I think,
All right.
I understand the need, the reason for your request, but as one board member, I don't think it's going to be a 15-minute hearing.
Well, as I said, we have no issues with any comments made by the professionals, but,
Even so.
okay.
Yeah, sorry about it. We'd like to accommodate, but we can't. Will they be first up on the next meeting?
Yes, besides if there's a small residential that comes on.
Okay.
The next meeting would be January 5th. The reorg is at 6:30, and our regular meeting is immediately following.
Okay. Mr. Eisner, you have that?
Sorry, I didn't hear.
No, that's okay. The date is January 5th.
January 5th, 2022. We start off at 6:30 with the reorganization meeting, and we following with the regular.
So that would be at 7?
No, earlier.
No.
That's why we're saying immediately after,
Okay.
because it usually takes us maybe 15, 20 minutes for reorganization.
All right, and I will confirm that there is no new notice or publication necessary, correct?
Yeah,
That's correct.
yes.
Correct? Pam?
Yes, correct.
Okay, thank you very much.
Okay, thank you.
And then the motion for that.
That's where we're at right now. Okay, so we need a motion
I'll make a motion.
to continue case 2106A Seagull Holdings till January 5th meeting.
Yeah, that's my motion.
Second.
Okay, any questions on the motion? If not, roll call, please.
Mrs. Kelly?
Yes.
Mayor Gilmore?
Yes.
Thank you, Sam.
Mr. McLaughlin?
Yes.
Mr. McKay?
Yes.
Mr. Jacochi?
Yes.
Mrs. Baggio?
Yes.
Mrs. Tyndale?
Yes.
Ms. Casco?
Yes.
And Mr. Pearl Pfeiffer?
Yes. Okay, minutes for the meeting August 4th. There were some changes that were made, correct?
they're just
Minor
minor
things.
things.
They're minor things. I need a motion and a second to accept the minutes.
I'll make the motion.
Yeah.
Okay, we have a second?
Second.
Any questions on the motion? If not, roll call, please.
I'm sorry, I don't even know this here. Mayor Gilmore?
Yes.
Mr. McLaughlin?
Yes.
Mrs. Kelly?
Yes.
Mr. McKay?
Yes.
Mr. Jacochi? Yes. Mrs. Baggio?
Yes.
Mrs. Tyndale?
Yes.
Ms. Casco?
Yes.
Mr. Pearl Pfeiffer?
Yes. We have a bunch of resolutions. First one is 2021-19, use variance and park temporary storage. That's the Philadelphia Hardware Group.
So move.
Any questions? Roll call, please.
Mr. McLaughlin can't vote on that.
I can't.
Oh, that's right.
Use variance, sorry.
That's okay.
I'll second it.
Just checking you out.
I'll make the motion.
Oh.
So Mr. McKay and Ms. Casco?
Yeah.
Okay, roll call, please.
Mr. McKay?
Yes.
Ms. Casco?
Yes.
Mrs. Tyndale? Ms. Tyndale?
Yes.
Mrs. Baggio?
Yes.
Mr. Bradley?
Yes.
And Mr. Pearl Pfeiffer?
Yes. Next one is Resolution 2021-20, which is the warehouse facility on Marne Highway, Blue Water property. Need a motion and a second?
Motion?
Is this Blue Water?
Yeah.
Yes, this is Blue Water.
There were a couple of minor changes on that resolution that they just came in today, as a matter of fact. The square footage of the warehouse building is 149,471. The resolution also said that the applicant would have 2 offices, and they asked me to change it to up to 2 offices. And the only other correction was the dates of the professional report.
Okay.
With those amendments, I'll move to adopt the resolution.
Okay.
Second.
Okay. Any other questions? Roll call, please.
Mr. McKay?
Yes.
Mr. McLaughlin?
Yes.
Mayor Gilmore?
Yes.
Mrs. Tyndale? Mrs. Tyndale?
Oh, sorry, yes.
Mrs. Baggio?
Yes.
Ms. Casco?
Yes.
Mr. Bradley?
Yes.
And Mr. Pearl Pfeiffer?
Yes. Okay, the next resolution is 2021-21, minor subdivision.
I'll make a motion, we approve 2021-21.
Second?
Am I allowed to, Paula?
Yes.
Okay.
All right, any questions on the motion? Roll call, please.
Mr. McLaughlin?
Yes.
Ms. Casco?
Yes.
Mr. McKay?
Yes.
Mayor Gilmore?
Yes.
Mrs. Tyndale?
Yes.
Mrs. Baggio?
Yes.
Mr. Bradley? Mr. Pearl Pfeiffer?
Yes. Next is the resolution that we amended, which is 2021-22, which is the rezoning that we get back to the Township Committee, that it is not inconsistent.
I'll make a motion.
Second.
Any questions on the motion? Roll call, please.
Mrs. Kelly? Yes. Mrs. Baggio?
Yes.
Mayor Gilmore?
Yes.
Mr. McLaughlin?
Yes.
Mr. McKay?
Yes.
Mr. Tricoci?
Yes.
Ms. Tyndale?
Yes.
Ms. Casco?
Yes.
Mr. Profiter?
Yes. We have 2 items of correspondence. I need a motion and a second to incorporate that into our,
I make a motion that we file correspondence.
A second.
okay, any questions on the motion? If not, roll call, please.
Mrs. Kelly?
Yes.
Mayor Gilmore?
Yes.
Mr. McLaughlin?
Yes.
Mr. McKay?
Yes.
Mr. Tricoci?
Yes.
Mrs. Baggio?
Yes.
Mrs. Tyndale?
Yes.
Ms. Casco?
Yes.
And Mr. Profiter?
Yes. Any professional comments?
None here.
Happy Hanukkah, Merry Christmas,
Yeah,
and
Merry
Happy New Year.
Thank you.
All right, now you don't have to. That was nice.
We don't have another meeting, right? This is our last one
January 5th.
for the end of the year,
Yeah.
pending reappointment.
Hey, I have a comment.
Yes, ma'am.
Just want to let you know, Scott, it's so awesome to work with you. I just can't get
Oh,
over
my
this.
goodness.
Just want to make you feel as good from me as you did from them, so. But truly, it is good to work with you.
Good team.
Yeah.
You too, Marty. You too, Bob.
No,
Make you feel equal.
Yeah, I mean, it's really, the town's working great. I mean, we had a lot of complex issues, and everybody's working really well together. It's really a nice to be part of everything in town.
Okay, any board
I
comments?
have to say that we do get a lot of compliments, truly, from our residents and our businesses, is that we are truly one of the better towns to work with at this board. I hear it a lot in my office.
That's because we all love each other so much.
Oh, geez.
Yeah.
I can tell the hour has caught up.
Somebody's got to,
No, wait, I have to
no, he's
go,
got to do public comment.
I have to do public comment, or board comments first. Any other board comments? No? Public comments?
Group hug.
No
there's
public?
somebody-
Wait, there
No
is
public?
still on.
Adjournment, all in favor? Good night. Thank you, ladies and gentlemen.
All right, who seconded that? You seconded that, right, Paula? It's good to me.
Yeah.
We still recording?